Lord, may I mention a matter, my Lord? Chief Surgical Lordship, may I mention a
I was on my submissions in volume 2.4, which your lordships had yesterday. We'd also given hard copies. I'll go very quickly because I've covered this ground. I just want to quickly run your lordships through the point. Internal page 19 of that, running page 22. I brought the Sikkim case to your lordship's notice under 14, 15 and 21. All three. Then at page 19, para 58, your lordships in Puttaswamy have also categorically held that the right to freedom of religion under 25 has implicit within it the ability to choose a faith and the freedom to express or not express those choices to the world. And these are an illustration of the manner in which privacy facilitates freedom. Then in the same judgment, your lordships have held at page 20 that the freedom of belief or faith in any religion is a matter of conscience falling within the zone of purely private thought process aspect of liberty, and that privacy is essential to the right to profess, practice and propagate religion within Article 25. And in Shafin Jahan's case, your lordships have held choices of faith and belief, including in matters of marriage, lie within an area where individual autonomy is supreme. So the right of decisional autonomy is well recognized as part of Article 21. In Kaushal Kishore, your lordships have noticed that several rights, including 25 and 26, have horizontal effect. They are not only against the state. Now comes to the questions my lords were posing to me yesterday about the scope of judicial review, because I think I must clarify that very clearly what my position is. It's not exactly the same as the learned Solicitor General, but it's also not an extreme position. I'm trying to tread a middle path. And it is this, if my lords would kindly see, I've actually set it out at page 29 of my supplemental submissions, para 82. Sorry, before that, may I go to para 63, page 22? I've just broadly summarized what is ring fenced, what judicial review, where judicial review should not, as a matter of practice, be.
Explain this to the concept. Kishore said horizontal effect.
Yes. No, that would mean that it's not available only as opposed to state action, but one can propound the right even independently of state action. That is broadly what is held. And as I told my lords, under Article 226, your lordships have recognized the right against a public charitable trust. So as long as there's a public charitable trust, these rights can be propounded. In my case, there is a public charitable trust. But just, if my lords would see page 22 at para 63, now these aspects, I believe, should be ring-fenced. Let me be very, very plain. I don't want to, my lord. The first is, if a practice or a belief, but a practice even, is proved undoubtedly to be the belief of that community or denomination, a judge is bound to accept that. But that proof has to be there. And your lordships have described that in various ways. Shirur Mutt itself said that of that there would not be judicial review. Bijoy Emmanuel said, and I've said this out at page 22, the court would certainly determine whether the belief is genuinely and conscientiously held as a part of the profession or practice of religion. So if the court is satisfied that that practice or the doctrine based on doctrine, text, whatever it is, has been established, and that is a genuine establishment, then deference, I believe, should be shown. to
Mr.
that.
Khambata,
Yes,
is your quoting of Ratilal Panchanand Gandhi correct?
yes,
They proved undoubtedly to be the belief of the Zoroastrian community. A secular judge has the word secular in the.
it has that. It refers to an old case, an old Bombay High Court judgment, where someone had left an endowment under his will.
No, they are qualifying a judge as secular in a judge.
Yes, I'll check that again. I'll have it checked, but I think it is there. It is there. I'll check it again. It is there. It's a very old, your Lordship is right. Secular meaning someone apart from religion. Any constitutional court would be apart from religion. Therefore, in that sense, secular. Now, there are two areas which have always been the subject matter of judicial review. And that I've covered in para 64 and 65 and 66. One is where there are competing doctrines or points of view within that religion. In fact, in my case, that's might arise definitely. But there your lordships have held in the Tilkayat case, which is the Nathwara temple case, that and I've just quoted that section at the bottom of page 22, in cases where conflicting evidence is produced in respect of rival contentions as to competing religious practices, the court may not be able to resolve the dispute by a blind application of the formula that the community decides which practice is an integral part of its religion, because the community may speak with more than one voice, and the formula would therefore break down. This question will always have to be decided by the court, and in doing so, the court may have to inquire whether the practice in question is religious in character, and if it is, whether it can be regarded as an integral or essential part of the religion. And the findings of the court on such an issue will always depend upon the evidence adduced before it as to the conscience of the community and the tenets of its religion. And then in Adi Saiva's case, just the first two sentences I'll read. Often occasions will arise when it may become necessary to determine whether a belief or practice claimed and asserted is a fundamental part of the religious practice of a group or denomination, making such a claim before embarking upon the required adjudication. A decision on such claims becomes the duty of the constitutional court. So the first step is it proved to be unequivocally part of the doctrine of the religion? And is there any conflicting view? No. If we reach that position, then a court should show judicial deference. Because it's not for a court to sit in judgment about the correctness of a practice or the rationality. That much, I think, is clear, and I don't think your lordship should interfere with that part of the law which has been well decided. Now, I have attempted at page 29, para 82, it's come in the wrong place, unfortunately, it should have come earlier, to set out which are the areas of judicial review that could potentially arise. At para 82, at internal page 29, the running page 32 in the volume.
Yes. Running page 32, internal
29. In my respectful submission, judicial review will be imperative in 6 areas. One is whether or not the doctrines of a religion include a particular practice. 2, whether practice or belief is a genuine practice belief enjoined by that religion and not an artifice. This is based on certain language used in the judgment. Now, this is a judicial review only to ascertain factual genuineness. Is it genuinely a part of that religion? Once that takes place, then the courts, in my respectful submission, should step back and not get into a judgment on whether it's a valid practice or a irrational practice or whatever. But then 3 onwards still remain. Whether a current organization or entity has the exclusive right to dictate what the doctrines of a religion are. Because you'll have, in my case, the trustees of this very trust earlier were allowing intermarried women in. Suddenly there was a change and the new one said no. That can't be a practice then. That's a personal predilection. Then 4, if there are conflicting doctrines or practices, then which of these is part of the religion and which not? 5, whether a matter of religion or a practice doctrine is contrary to public order, health, or morality, that is in the article itself. And 6 is what I'm coming to now. Whether a practice of religion in a particular instance collides with a competing fundamental right under 14, 15, 21, 25(1). If so, then how the doctrine of balancing or harmonious construction or double proportionality is to be applied to save the precise interests or core of both competing fundamental rights. To that end, the precise interests or core of the religion will necessarily have to be determined. I'm coming straight to that.
But the difficulty for us is this. Now you are asking us to get into an arena where we have to adjudicate upon the rights of A against B. It is not, according to, as rightly you rely upon Kushal Kishore and say, normally when you define a non-state actor, it will be an unknown face.
Yes.
But what you are actually contending and expanding that to mean a member of the denomination who is not in agreement with the religious practice, can you actually question the religious the denomination's right? How does that come within the purview of the judicial review of a constitutional court?
That is the
It
key
may be a
question.
case for you to file a suit or anybody.
No, that is the key question.
But,
My lord is right. That's what I'm trying to.
Now, we are only conscious about our own jurisdiction. Once we
Undoubtedly.
open it up,
And that's a good
where
thing.
do we end? And we'll be having thousands and thousands of cases of
No,
this
no.
nature.
For the respondents in the writ petition,
Yeah.
The respondents are the trustees of a public charitable trust who administer
So Kishore
place
doesn't
of
do
worship.
so.
that they won't come under Article 12.
But 226 will lie, that your lordships have held.
Of course,
Kishore says that right, but that constitutional right can run horizontally as against the person on the premise that person is not exercising his own right under the constitution. All right, if a violator, if he violates like Article 17, you can take. If somebody violates it, you can always say that it's mandate is violated. But when somebody claims it as his right,
May I suggest,
the constitution,
may I propound
to adjudicate upon rights
an example?
on a disputed factual premise.
No. I accept what's
regard to
falling.
Article
I accept that.
17, there is an act.
Yes,
There is an act which is made pursuant to Article 17.
yes,
And under that, the disputes are adjudicated.
yes. That would be also.
Yes.
That would be.
Civil Rights Act.
No, I make it very clear, that if there is,
In the simplest terms, question number 1 to 4,
Yes.
out of the 6 which you have formulated,
yes,
are essentially 1 to 4 are predominantly question of fact. Predominantly,
yes,
and 5 and 6 are the legal consequences.
my lord is right.
So what my brother and sister have pointed out is that what should be the form? Because if it is a question of
understand.
fact, then it would require
A civil suit.
it would require evidence. So
But
probably we are maybe that to that extent impliedly, probably we also might be inclined to agree that the issues would require judicial adjudication.
yes,
The question will come only of the form
my lord is
and
right.
the substance.
I am obliged to my lord because that would be a correct formulation. There will be cases and cases. And again, not because I want to cite the facts of my case, but my case is a good example to give. In my case, no practice has been set up because, in fact, we have produced letters and resolutions from various Parsi Anjumans all across India saying we always allow women in.
We are on general principle.
General.
Your case,
So, in a given case, a practice may not be set up. That's what I'm saying. I'm saying mine is only an example. There may be, to start with, not a practice. Then a court has to look at the trust deed and say, does the trust deed permit you or not? That's all. Therefore, there will be cases and cases.
So, and secondly, whether this ban on the lady marrying outside the religion, whether is it a matter of religion?
No, I can unequivocally say it is not. And let me put it another way. The High Court itself has found that even a Parsi lady marrying outside retains her religion. As a matter of fact, that's a finding of the High Court. And they said no material is put before us to show even a non-Zoroastrian cannot enter. Now, I must say, in fairness to the other side, Before your lordships, they produced a whole lot of material and we've countered that. I'm not getting into the facts of my case, but my lords may take it that there's nothing in the material they produced which at all shows that there's anything in the religion which somehow prohibits, ostracizes, or excommunicates only a Parsi lady for intermarrying. They have relied on certain texts, which also is wrong. Because if you read the actual text, which they've given the translation, it doesn't say what they've said in the submissions. But the highest case is the intermarriage is frowned upon. But they don't meet the elephant in the room, which is then how do you allow intermarried men and their children in? So that's a matter, these are certainly areas for the court to go into. Otherwise, any institution will get up and based on the personal predilections or even sincere beliefs of its trustees say, no, you can't come in. Then the next set of trustees say, all right, you can come in. That can't be a means of exclusion, is all I'm saying. If there's a genuine established belief or practice, then yes, judicial deference must be shown.
Question put forth by Honorable Chief Justice.
Yes.
See, so far as your case is concerned on merit, prima facie, we find something.
Yes.
But what would be the forum then? See, if it requires an adjudication, like you were saying, the trust may take a different stand today or tomorrow, they may rely upon something, change. But can we go into that factual adjudication?
No, my lord, I agree with my lord. If someone that
So
in your
hard case make a good law.
yes,
or in your soft copy submissions, you perhaps dealt with this issue, saying that these issues, the power under Article 226, maintainability is not in doubt, but entertainability is
Yes.
completely with the
Yes.
court,
of course.
depending on the nature.
I
of
bow
the
to
case
that. I bow to that completely. There's no
No,
question.
I think I'm
Yes, I have.
hearing it from your.
I have, my lord is right. I'm not there. I want to just clarify if I gave any wrong impression. Of course, that's within.
Like, are you saying that the practice which should be uninterrupted being followed for a long period, not subject to somebody who is managing the affair of a denomination?
That is one point. My lord is right.
That is at the
Yes.
will and wish of somebody managing the denomination.
Yes.
And it changes as per there is a change, there is a practice change in the practice, or there is an interruption in practice, then such practice is not necessarily a practice, religious practice or essential religious practice being followed uninterrupted.
My lord, please.
And their court can,
My lord.
the intervention of court may be subject to a
My lord,
particular
please.
case. Is
And secondly,
acceptable of-
where indisputably the same denomination, assuming it's a denomination, different parts of the same denomination follow different practices. Also, it shows it's not a practice of the denomination. But my lord is right. These are the essential 2 points. They don't arise in most cases. In some cases they do, and I believe in my case they do. Now, my lord,
It is not a matter of religion with regard to this
That-
ban on entry. Then you can always seek a civil relief, filing a suit.
precise. I can always seek enforcement of the trust deed because it's not a matter of, it can't be a matter of religion if some people allow, some people don't, within the same denomination or the alleged same denomination. Therefore, ex facie it can't be.
Then file a suit for mandatory injunction.
I don't need to. It's the other way around. I was always entering. If the current administration stops me, they would have to establish the exclusionary practice in a civil court. That's what the High Court also seems to
So
have.
if they stop you, then you are the aggrieved party.
I'm the aggrieved, but it can't be that the present administration manages to stop me, putting the onus on me to go to a civil court. I can understand a long-standing practice. That's a different matter. But where I have been going and people similar to me have been going, and suddenly I'm stopped, then surely the burden is on that person to establish it in a civil court. That's my submission. I place it. It can't be that
Still then,
to worship I have to
you may require to
spend
go
years
to a
in
civil
litigation.
court, not to get a declaration as to your practice, but as an injunction on your entry.
Yes.
So an injunction suit will be, it's not a declaratory
Yes.
suit. And
But-
there, if a rebuttal is given in a written statement that
Yes.
we have as a matter of religion, this practice of excluding married women, it will become a matter in issue in the suit.
And that they would have to then
Yes. So where the
prove in
in your submission, where the High Court has gone wrong, is the presumption which has
Presumption.
been articulated against it.
I'm obliged. That is my real complaint against this judgment. That presumption in law doesn't exist, and it'll have far-reaching consequences across religions, not only limited. No, not.
To the relief, please see the dissenting opinion in Kaushal Kishore. Where is the relief? Because everybody reads the majority, nobody reads the dissenting. See the dissenting opinion as to where you should go for your relief.
I will certainly. I will certainly. Now, my lord, I come to an area which might not strictly arise in my case, but or it may arise. I'm not prejudging my matter, but it's an area that will arise in most matters if there are assertions of competing fundamental rights. And my lords put to me that we've been hearing these terms: balancing, harmonization, proportionality. How do we do it? Now, the best I can offer is two judgments of your lordships and one interesting judgment only by way of example of the European Court of Justice, faced with a similar sort of situation. So page 24 of my note first, para 69, running page 27 if the soft copy is me. This is in the electoral bonds case.
Yes.
Association for Democratic Reforms. Your lordships recall the conflict there was between a right of privacy asserted regarding political donations versus the right to information and freedom of information. There were the two fundamental rights in competition. And your lordships adopted what is called a double proportionality standard. The normal one is single proportionality because you're analyzing a state action and its impact on a fundamental right. But here you have two competing fundamental rights, therefore double proportionality. And your lordships held at para 155 that the court, while balancing between two fundamental rights, must identify the precise interests weighing in favor of both competing rights. And then a four-pronged structural standard was framed, which I'll just read out. First is, does the Constitution create a hierarchy between the rights in conflict? If yes, then the right which has been granted a higher status will prevail over the other right involved. If not, the following standard must be employed from the perspective of both the rights where rights A and are in conflict. So in other words, does 26B, is it given a hierarchy or higher status than either 25(1), 21, 15, 14? If so,
This route we will be required to follow only when we agree with this perceived conflict between 25(1) and 26.
My lord is right. That would
be.
If there is a conflict. If there's no conflict, then it doesn't.
This word, very popularly, this word harmonize has been used. At least speaking for myself, I am not convinced that there is a need of this harmonization business here.
I understand.
There are two different kind of rights, different kind of principles.
I understand.
But you are right.
In the event
of a conflict.
In the event of.
Only in the event.
My
This
lord.
is the most appropriate route
Then
we
the
follow.
second is whether the measure is a suitable means for furthering right A, right B. Third is the measure should be least restrictive and equally effective to realize both rights. And finally, whether the measure has a disproportionate impact on either of the rights. And in the last stage, your lordships have held that the court undertakes a balancing exercise to analyze if the cost of interference with the right is proportional to the extent of fulfillment of the purpose. It is this step that the court undertakes an analysis of the comparative importance of the considerations
There's no
involved.
difficulty, Mr. Only point is,
Yes.
what we are asking is this, whether this principle can be introduced into 25(1) when you can consider the right under 25(1) between the two competing groups.
Yes.
So now, concedingly, 25(1) NUs to the benefit of the group which actually professes or practices. You question it. Therefore, to that extent, they are entitled to claim under 25(1). The question will be whether you will be entitled to claim under 25(1) as against that person.
Yes.
But
Yes.
then, nonetheless, as Nalam said, still you will be able to assert your right under any other law, including the other parts of the Constitution. before by filing the suit, in which a defense may be to them under 25(1). It is having my fundamental right, therefore it infringes this. But to say these two rights can be read into 25(1), to resolve a conflict there and there, it's a bit difficult for us to appreciate.
So this is an alternative argument. My first argument that 25(1) and 26 should not be read as in conflict. 26 flows out of 25(1). I'm assuming that your lordships perceive a conflict in any case.
Well, your argument is that this is the safest way.
Then this is the safest way, it is a time-tested way. And what is the right under 26B? There was a very interesting, as I said, a very short but very neat argument on behalf of the Bombay Parsi Panchayat, where your lordships were told hard cases don't go on the basis of sympathy because your heart may bleed for a particular person, but remember the right of autonomy of a denomination. Now, that's not my argument. 26B, no doubt, is fundamentally a right of autonomy from state action. That is unaffected by this. But 26B is not a right of domination. Please don't conflict autonomy with domination. Merely because there's a conflicting belief doesn't mean that religious autonomy is affected. That autonomy against the state remains. Therefore, sometimes we conflate religious autonomy with denominational control over individual members or domination. That confusion should not be there. 26B essentially is against the state, it's against state action. And a right of exclusion of an individual member will no doubt have to be established on the basis of religious doctrine. It doesn't just arise because we have a right to organize our affairs in matters of religion, or to arrange our affairs or manage our affairs in matters of religion. Now, therefore, that's the fundamental or precise interest of 26B. It's against state action. On the other hand, what is the precise interest of 25(1)? And there I do comment that the time-tested, integral or essential part of the religion, of in one or two cases, fundamental part of the religion, these are good instruments by which to balance these rights. So even if your lordships are not minded to specify the right to religion in narrow terms to start with, when it comes to balancing or proportionality, this is the only way of doing it. Because otherwise, what is an inessential practice, which is not really proven to be part of a doctrine of a religion, cannot trump the right to freely profess, practice, and propagate religion. If there's a conflict between, in the event of a conflict, that's the only submission. And I've set out at page 25 the time-tested, the trilogy, Shirur Mat, Ratilal Gandhi, and Venkatrama Devru.
Yes.
And later followed also by Sardar Swarup.
So whatever defense is available
Yes.
against the state,
Correct.
same defense they can propound against another individual also.
They can run. And this is why Venkatrama Devru actually gives a very nice solution, though not in the context of other fundamental rights, in the context of 25(2)B, because it said the exclusion is not a complete exclusion. It's only from certain ceremonies where the head of the Mat and certain members of the Gauda Saraswat Brahmin community were allowed. You're not preventing the rest of Hindus of coming in at all other times. Therefore, their right to profess, practice, worship is not that affected. Balance the two. And that therefore is a good path to keep in mind. Now, one judgment, if your lordships kindly quickly see, it's only as an example. Page 27, the judgment of the European Union Court of Justice, which in its charter, para 76, had recognized the right to freedom of conscience and religion. But a regulation was made that animals would be slaughtered only after stunning them, because that was thought to be a kindness to the animals, not slaughtering them without first making them unconscious by stunning. This was challenged on behalf of the Jewish and Muslim communities, saying this conflicts with our religious practices and rights. And they oppose stunning. Now here what the court did was to balance the religious rights which were protected by way of freedoms and this law. And they asked themselves the question whether this was an essential religious right. Was it something that was fundamental? Did it have profound personal religious importance? Was it strictly, and was the derogation from that by the requirement of stunning strictly necessary? And they balanced the two by saying, if you do not interfere with a key feature of the religion, then a regulation like this can be protected. And similarly, in para 80, a judgment of the House of Lords, where the inquiry was at the bottom of page 28 in Williamson, when the genuineness of a claimant's professed belief is an issue in the proceedings, the court will inquire into and decide this issue as a question of fact. This is a limited inquiry. The court is concerned to ensure an assertion of religious belief is made in good faith, neither fictitious nor capricious, and that it is not an artifice, to adopt the felicitous phrase of Justice Ayubashi in so and so. But emphatically, it is not for the court to embark on an inquiry into the asserted belief and judge its validity by some objective standard. That is the balancing. Well, that concludes really my address on, with my limited abilities, offering a solution. It's not an easy proposition. I have, and I won't trouble my lords with, I have actually set out a summary of all my conclusions, starting with from page 30. I have already argued all of these.
That is still number 7.
Yes. In 7, I put the whole lot in one place.
In fact, this is the complete summary of your report.
I've tried to just summarize the conclusions by putting them one after the other. I don't want to again waste my lord's time by reading them. But I just want to end with one thought. Your lordships are called upon to interpret a constitution, not just a mere statute. And that interpretation will impact the lives of over 1 billion people, because religion is so important in our country to everyone. Please keep in mind that constitutional silences are not the same as constitutional vacuums. So many matters, your lordships, without express language, have decided, starting with the collegium system under Article 124. Right to health, right to privacy, right to decisional autonomy under Article 21. Doctrine of arbitrariness under Article 14. There's no express language. Nevertheless, your lordships have read that, have given meaning to the silences and content to the silences. So both 25(1) and 26(b) must continue to reflect what I started with, our ancient civilizational values of mutual respect, tolerance, peaceful coexistence, and plurality of belief, practice, and decisional autonomy. This is really the ancient ethos of Hinduism. As I said, that's how my community has survived for 1200 years. It's when one thinks about it, it's the most amazing thing. And that essence and that core is embodied in 25(1). Now, to say that 25(1) has it, but 26(b) is not shackled by it, would really damage this architecture. So please, my request is, and I commend this as a submission, no primacy or hierarchy or one trumps the other. Both have to be read together. It's a daunting task for your lordships and for any court, but it's a noble task. And it's a task that has to be done to maintain this balance. 26(b) is part of a pattern of guarantees. It's not an island, much less is it a fortress, much less is it a provision to dominate any other fundamental right. And therefore, balancing, which is always the most difficult task of a court, with no doubt about that, is really the only answer. And I think the past also courts have tried to balance it. Devaru is the classic case of balancing, and I humbly and respectfully submit that that is what I commend to your lordships. I'm deeply grateful for a very patient hearing.
Thank you.
I hope I have not exceeded my time.
Thank you.
I'm grateful.
So, Mr. Raju, you will start or Mr. Srivastava will start?
Suggestion I have received request, all those in the RC matters, let them supplement minutes so that is over. There are 2 or 3 councillors who made a request if you supplement Mr. Kambata by 10 minutes or so, if they wish, once they make, then I can start, so that the Parsi matter is complete. But other requests are coming, which I don't know.
From our side, we have no difficulty. Whatever way you have resolved, you please proceed accordingly.
To this extent, only to this extent, your lordship, Jawaharlal Nehru had a cousin named B.K. Nehru. Jawaharlal Nehru had a cousin, B.K. Nehru. He was an internationally famous diplomat, Millets. The title of his autobiography was Nice Guys Finish Second. All that I request is that this not so nice person comes third and not fourth or fifth or sixth. That's all. Let the Parsi side finish, Millets.
No, why don't you start?
No, Millets, it'll be a logical sequence, Millets. If they can finish by lunch, then I'll start, Millets. No problem at all. I've also committed both to Mr. Srivastava and to my young friend that they can supplement Mr. Kambata.
I'm not at all in hurry, Millets. I'm so not the Mr. Ramchandra.
No, no,
I thought that the young laws will have at least the old convention and the best practices that first of all seniors are requested to assist the court.
That's right.
Whatever your lordship
I
said.
agree, Millets.
Will you finish my lunch?
I'll take 15
I'll
minutes.
not,
I'll
Millets.
finish in
I'll be as brief as possible. But
Both of them finish by lunch, Millets.
Lordships. Lords, a couple of points that I want to add in respect of, Lords, the factual aspect that Mr. Khambata had addressed your Lordship. Lords, may I just hand over my note, to your Lordship? Come on, quickly. Lords, we've kept it as brief as possible. And Lords, these are only the additional judgments. We've quoted them, so I won't be troubling your Lordships with reading them. Sir.
Yes, please.
Yes, Lords. Well, your Lordships have heard from Mr. Khambata the factual aspect regarding Gulru Gupta's matter. In a sentence, my lord, a Parsi Zoroastrian lady, my lord, born into the Parsi race, had her Navjot done, professing the Zoroastrian religion, married a Hindu man under the Special Marriage Act. And my lord, the Gujarat High Court eventually, told by the Valsad Anjuman, the respondents in this matter, that she will not be allowed to attend the funeral ceremonies of her parents when they should eventually demise.
That we have already read.
Lordship. Lords, I want to add one additional factor to your Lordships, and my lord, quote from a 1908 judgment of the Bombay High Court, a division bench. Lords, the word Parsi actually comes from the... Come on, hand it over more. They want more copies. The word Parsi comes from the word Pars, a province in, my lord, ancient Persia, today modern day Iran. The word literally translated means from Pars. Parsis are the descendants, my lord, of the initial Persian refugees. I've captured that in paragraph 2 of my note and 3 of my note. The Persian refugees who escaped, my lord, Arab Islamic religious persecution in between the 8th to 10th centuries, left with the holy fire, stumbled, my lord, across different parts of the world, and eventually landed at the shores at Gujarat. The race is, my lord, all of us are effectively, my lords, the descendants of those initial refugees. Now, today, my lords, your race, your ethnicity is an accident of birth. How can that, with the greatest of respect to the Gujarat judgment, ever be taken away from you by your act of marriage? To hold that you cease to be a Parsi, my lord, the Zoroastrian part I'll come to separately, but to say that you cease to be a Parsi because of your marriage to a Hindu man, with the greatest of respect, my lord, can never be. That's, and why I'm saying this is, my lord, ultimately when your lordships are considering the first question and the second question which your lordships have framed regarding articles 25 and 26. Zoroastrianism or Zoroastrians, my lords, Parsi and Zoroastrian are used interchangeably. Zoroastrian is the religion of those who follow the religion, my lord, professed by Prophet Zoroaster. We are all Zoroastrians once our Navjot ceremony is done and we are inducted into the faith. Though the words are used, my lord, interchangeably in common parlance, effectively that is the difference between the two words. Now, my lords, for the judgment to hold, therefore, that, my lords, though she was married under the Special Marriage Act, she ceases to be both a Parsi and a Zoroastrian, in my respectful submission, my lord, follows the common law practice, my lords, which your lordships put to Mr. Khambata yesterday. It was a common law practice effectively that a woman in that sense takes the ethnicity or the religion of her husband upon marriage. But with the advent of the Special Marriage Act in 1954, lords, with my respectful submission, that can never be, because ultimately your lordship's court has held, and lord, we've cited one judgment in Union of India versus CCOM, has held that once there is a special act of a special statute enacted by Parliament, then that can never, the common law can never trump that. So in my respectful submission, my lord, once the Special Marriage Act has been enacted, it's meant to effectively preserve both ethnicity and religion of those marrying thereunder. So to then discriminate against a woman and say that she cannot enter the fire temple, she cannot enter, my lord, the Dungarwadi for the purposes of her husband, her parents' last rites, etc., because she is now deemed to have become a Hindu, with the greatest of respect, does violence to Article 25.
Did you hear the observation of Honorable Chief Justice yesterday?
Yes, my lord.
Honorable Chief Justice only pointed out this, the specific provisions.
Yes, my lord.
It completely, it makes the other, even assuming it is a practice, it gets automatically gets removed by virtue of the operation of the act. That is why, like Honorable Chief says that whatever the issue you decide here, you can still test it on the premise where you have a premise. Okay.
I'll straight away come to Articles 25 and 26, my lord, and I've captured that in my note. Lord, this part about, Lord, the distinction between Parsi and a Zoroastrian, if your lordship see paragraph 3 of the note, Lord, this is exactly what has been set out by a 1908 judgment of the Bombay High Court, receiving, Lord, tons of evidence on the point, the distinction between a Parsi and a Zoroastrian. That's the additional point to Mr. Khambata that I wanted to make. Lord, insofar as Articles 25 and 26 are concerned, one point that I wish to place before your lordships is this. Lords, my Lord Justice Amanullah posed a question to Mr. Khambata yesterday. Will the rights not be different under 25 and 26, considering that 25 pertains to citizens and 26 pertains to the denomination or the institutions? But I would respectfully submit this. Your lordship is absolutely right. But the distinction would be that, Lord, Article 26 applies to the denomination, Article 25 would undoubtedly apply to the individuals. But at the end of the day, the individuals are nothing but, the denomination is nothing but the collective of the individuals. Therefore, to read the two independently, in my respectful submission, would do violence to the language of 25 read with 26, and taking a segue from what fell from my Lord the Chief Justice just a few minutes ago to Mr. Khambata. Lord, on this aspect of harmonious construction, I would respectfully submit this. Undoubtedly, my lords, the denomination has the right under Article 25 to, my lord, manage its affairs. Nobody is saying no for a moment. The question that we pose for your lordship's kind consideration and that I ask myself is, can in the management of the religious institutions and its administration, can you trample upon the individual rights guaranteed under Article 25? Your lordships posed a question yesterday regarding the balancing. I would respectfully submit that the balancing would effectively come when you say that, my lords, the rights which are preserved under Article 26 can undoubtedly be exercised so long as they don't trample over the rights which are guaranteed under 25. That would be a harmonious reading of the two. That would preserve the rights of the religious denomination under Article 26 and preserve the rights of the individual under Article 25. And therefore, my lord, we respectfully submit that you can never not read the words subject to the other provisions of Part 3, even in Article 26, because can you ever say that the other provisions of Part 3, Articles 14, 19, 21, for example, will apply to the individuals, but will not apply to the institution? It will lead, in my respectful submission, to an absurdity. And therefore, what I have also captured in the note is, my lord, even if your lordships... Yes, my lord.
The danger is that you are your individual capacity before us.
Yes.
We will not take you as representative of the Zoroastrian religion.
It's across the board. Lordship.
We are also not sure that you are actually representing this Golrak Gupta, for whom Mr. Khambata has already argued.
Yes, Lord.
So, you please, first of all, you clarify that is it your individual opinion or you are presenting a denomination or what's before us? In what capacity you are
I'll tell you, Lordships. Lord, I am an
This is the danger we are facing since 2006.
Lords, I am an
Intervener.
Yeah, I'm an intervener in the Golrak Gupta matter, supporting her, of course, in my individual capacity.
If you want to tell us something about Zoroastrian, it's all right, about religion. Because we gave you time over and above the senior counsel,
Yes.
only because you will explain something about Zoroastrian.
Milord, that I
But
have
we don't want anything else.
we've captured that in the first part of the note. Milord, I was only attempting to assist your lordship.
So that's
Milord,
fine.
on
That we can
Articles
wait for your
25
time.
and 26.
Much.
On 25,
Substantial
26,
arguments
we
have
will
been
hear the
made.
senior counsel first.
Milords, can I only request your lordships for 5 more minutes, Milord, to read a certain part of the note which has thus far not been addressed?
All right.
Yes.
Now finish it quickly.
Yes. Milords, if your lordships kindly come to page number 6 of the note, in page number 6, Milord, from paragraph number 15 onwards, Milord, we've given your lordships, Milord, what our submissions are in respect of the harmonious construction
You
of.
are saying our submission. You are representing whom?
I'm sorry, Milord.
That is the danger we are.
My submission, Milord, as the
You are
individual.
some individual who want to
So
give
we
your
will
own
not- We
opinion
are not going
in
to
the
those
matter.
issues, only with respect to as Manal CV said, with respect to explain anything you want to say on Zoroastrianism and possible reason, you can, to that extent, please.
Can I
Yes.
only place 3 doctrines for your lordship's kind consideration? And I will leave it at that.
Yes.
Milord, in Milord, my note, if your lordships kindly have a look at paragraph 12,
Yes, please.
Milord, we have set out of course, the basic structure doctrine as encapsulated in Keshavananda Bharati, Milord, that needs no further introduction. And Milord, there's a concept now of this living tree of jurisprudence, which we have found 5 judgments of your lordship's court. May I just read that, Milord, in paragraph numbers 31 and 32.
31, 32.
31, Milords, we've captured Keshavananda Bharati. I won't trouble your lordships with reading that. But if your lordships kindly see 32,
Yes.
the basic structure doctrine does not make the constitution stagnant. Rather, it is an evolving mechanism that is greatly influenced by the directive principles of state policy and the preamble. As societal conditions change, the judiciary evaluates the goals of social justice.
Dr. Dhawan has read it there. Dr. Dhawan has read
Yes.
it.
And Milord, the 3 judgments that we've cited there.
You are supporting the petitioner?
Yes, I'm supporting the petition.
Very well.
Milord, the judgments in IR Coelho, Ashok Kumar Thakur, and State of West Bengal follow this Canadian principle in Edwards versus Canada of this living tree jurisprudence. Milord, they make this doctrine that ultimately the constitution is to be taken akin to a living organism. It has, Milord, its own ethos. It must be adaptable. And of course, at the end of the day, you must interpret it taking into account, Milord, social progression over the years. And therefore, Milord, this doctrine of living tree jurisprudence or the living tree doctrine has evolved. And even in modern, Milord, in modern judgments, Milord, in paragraph 34, we've captured in Z Telefilms and National Legal Services Authority. Lord, lastly, if your lordships kindly have a look at Lord Mr. Khambate has argued R.C. Cooper. Lord, in R.C. Cooper, I just wanted to point out one thing. If your lordships kindly have a look at paragraph 37 at page 15. Prior to R.C. Cooper, there was a judgment of 1950 in the case of A.K. Gopalan. A.K. Gopalan initially read, my Lord, Article 21 separately from Article 19 and said the right to preventive detention under 21 does not need to fall within the test of Article 19. Ultimately, R.C. Cooper overruled it and eventually held that you cannot hold fundamental or you cannot treat fundamental rights in watertight compartments or silos. They have to be read together. And therefore, my Lord, the submission that I place for your lordship's kind consideration is when your lordships are testing the exercise of fundamental rights under Article 25 or 26, they cannot be interpreted in such a manner where the exercise of right by one will trample upon the exercise of fundamental rights under the other articles of Part 3 by another. That's our respectful submission. And the last point that I want to make is, my lords, this the evolving doctrine of non-retrogression. That I have captured at page 17. Paragraph 44 at page 20. I'll only read this quotation and my lords end at this from Navtej Singh.
Yes, we got.
Yes, this honorable court in Navtej Singh has propounded the doctrine of progressive realization of rights and non-retrogression. This honorable court has held that the state must move forward and refrain from adopting an approach or interpretation which will result in regression of rights. The relevant portions of the judgment are reproduced below. And lords, I would only end by saying this. Lords, if your lordships were to eventually hold that 25 and 26 are not to be read harmoniously, are not to be interpreted purposively. Your lordships have always told us the golden rule of interpretation of statutes, purposive interpretation. Even if the result results in an absurdity, then your lordships can always read words into or deduct words from a particular provision. Lords, I would respectfully submit that please, ultimately to achieve the balance as Mr. Khambata submitted before your lordships, Lords, the exercise of rights by the religious denomination under 26 ought not to trample upon the exercise of rights by the individual under 25. And that would really be the balance. That would, in my respectful submission, be a harmonious reading of the two. I'm deeply obliged to you.
Thank you. Thank you. Thank you.
Depend whether he continues to be.
So that's fine.
May it please, Willards,
Yes, sir.
this first. To be very honest, Willards, I must clarify one thing that both Mr. Khambata and I are appearing in the Gulruk's matter, that Parsi matter, Willards. I'm aware that your lordships normally not permit two councils to address Willards. But in this particular case, Willards, I may perhaps.
As long as you are not repeating, it's fine with us.
Yes, Willards. I believe that Mr. Khambata has lightened my job, Milords, because I would broadly follow his submissions, Milords. But if your lordships permit, I may supplement them only, Milords. There may be some overlapping, Milords, but that is unavoidable sometimes, Milords, say. But the approach may be a little different, Milord, that's all. Now, the two things, Milords, of which I must caution myself, Milord, at the very outset. One is, your lordships are, my lords, when considering these 7 questions for answer, are not considering, my lords, in the context of A case or B case, my lords. These are purely, my lord, constitutional questions. They involve, my lord, the interpretation of the Constitution. They are not religious questions as such, my lord. So as I read all these 7 questions, my lord, which I said. Some other forum, some other court, my lord, so some other, my lord, will answer, my lord, the individual issues, my lord, on the facts of each case or the controversies which have, my lords, arisen in those particular cases in the light of your lordship's authoritative pronouncement. This is, my lord, so my submission, therefore, my lord, is this. I have divided in my, my lord, submissions, if your lordships won't mind, under certain headings, my lords, and I will not read all of them, only some of them, my lord, which are, I think, will give some insight, my lord, hopefully. Thank you, copy. If I may say so, my lords, very briefly, my lords, just why so that, my lords, I would articulate my submissions accordingly. My lord, there are 3 or 4 aspects of the matters, my lord, which essentially fall for your lordship's determination. One is, my lords, while your lordships are interpreting Article 25 and 26, which your lordships will do in this matter, the essential, my lords, aspect of the matter is what is the interplay between Article 25 and 26. That's the basic, my lord, and most of the answers will follow that. What is the interplay, my lords? The second, about which there has been much controversy, my lord, and a lot of submissions have been made, is with regard to the correctness of the essential religious practice, my lords, which has been, my lords, interpreted, my lords, in the Varu judgment, my lord, and in, my lords, the first, according to me, in Shirurmut, and then, my lord, in Dirgah judgment. The third aspect, my lord, is the constitutional morality principle, which has been read into Article 26, my lord, while interpreting the morality, the word morality, whether constitutional morality has any constitutional sanction, my lord, and must be adopted as a controlling factor, my lord, for interpretation of Article 26. In addition, my lords, I have a submission, my lord, which would deal with and try to assist, because series of decisions, my lords, ever since 1954, they for much, and which have been followed, my lords. I have a list of all those cases by now, by more than 100 cases by now, my lords, are sought to be, my lord, reconsidered and overruled, my lords. Now, whether a case of overruling, my lord, has been made out, whether, my lord, the principle of stare decisis will be, my lord, applicable in these cases. I'm not doubting your lordship jurisdiction, my lord, so far when your lordships are sitting at 9 judges combination, a larger bench, my lord, to reconsider if it becomes so necessary, if there is a manifest erroneous interpretation given by the court earlier, my lord, in ignorance of any provision of law or the constitution, or, my lord, in some binding precedent. And it is so imminent, my lord, eminently necessary in public interest to prevent a mischief or a public injury. I am not doubting your lordship jurisdiction, my lord, to reconsider or revisit the decisions. But the question that one has to ask is this: is a case, my lord, really made out within the parameters which your lordships have already set out, my lords, in numerous decisions, while my lords laying down the principles of stare decisis, the doctrine of stare decisis. So there are basically, my lord, the four areas, my lords, in which I'll try to assist your lordship, my lords, and not go beyond that. May I request your lordships, my lord, to please come to page 16 of my submission, my lords. And the best way, my lord, I adhere to the time or I take minimum time is, my lord, to place my submissions, my lord, which I have penned down. And then, my lords, any questions which your lordships may have in mind, my lords, they're welcome, my lord. I will try to answer them to the best of my ability and, my lords, in my humble way. Kindly come to page 16, my lords, of my submission. And this is something, my lord, which Mr. Khambata, my very learned, my lord, brother, my lord, has already touched upon. But, my lords, may I also, my lord, in my own way, place it. Interpretation of Article 25(1), the meaning of freedom of conscience. My lord, I am laying particular emphasis on the words, my lord, freedom of conscience, which is used in Article 25(1). Constitution makers, in relation to the right to freedom of religion, basically wanted to guarantee to all persons that they are equally entitled to freedom of conscience. The emphasis is on freedom of conscience, which is vested in all persons equally. The freedom of conscience is the main fountain source of the fundamental right to freedom of religion, which is intrinsically connected by use of the word and in Article 25(1), and further is an adjunct to right freely to profess, practice, and propagate religion. What I really mean to say is this: the guarantee of freedom is freedom of conscience. And, my lord, what follows next is, my lord, the right freely to profess, practice, and propagate religion is an adjunct of it, my lord, which follows the freedom of conscience by way of practices, my lord, by way of outward manifestation, my lords, by belief, etc. In other words, what is guaranteed essentially as a fundamental right is freedom to conscience, and the application thereof is the right freely to profess, practice, and propagate religion. It is not possible to conceive a right freely to profess, practice, and propagate without the freedom of conscience. What is guaranteed as freedom of conscience is followed by the outward manifestation of the same by the person under the right freely to profess, practice, and propagate religion. The first part of the guarantee, namely all persons are equally entitled to freedom of conscience, is guarantee of faith of the person, and second part of guarantee, namely and the right freely to profess, practice, and propagate religion, is a guarantee of the acts done in pursuance of the faith of the person. For a person who entertains a faith, the Constitution does not allow it to be questioned, much less provides any means of investigation, because that precisely is the freedom guaranteed by the Constitution. The conscience of the person cannot ever be questioned by anyone. The only question is whether such a person or faith is entitled to claim his freedom or do or perform things which are not forbidden by law in the matter of practicing, professing, or propagating religion. Every person has a fundamental right not merely to entertain the religious belief of his choice, but also to exhibit his beliefs and ideas in a manner which does not infringe the religious sentiments, rights, and personal freedom of others. But I have referred to Lily Thomas. It will not be out of place to notice some distinctive language expression used by, I think your lordship's time to rise for the for the lunch. I'll continue on.
You are on point E.
Well, E, Lord, I was just coming to E.
You can
Yeah,
conclude
yes,
so that
it will not be out of place to notice some distinctive language and expression used by the framers of the Constitution in Article 25(1) of the Constitution. Why, in relation to freedom of conscience, the Constitution uses the expression entitled to, whereas in relation to the freedom to profess, practice, and propagate religion, the expression used is right. Entitled to creates, well, that's my very respectful submission. Entitled to creates entitlement as a vested, fundamental, and guaranteed fundamental right, and is an expression of much stronger import and force than the statement of right. This would show that the freedom of conscience is the heart and soul of Article 25 of the Constitution, and the right to profess, practice, and propagate religion in accordance with individual conscience is an outward manifestation of the freedom of conscience of the person. My Lord, there's a case note, my Lord, which I have prepared, my Lord, which gives all the cases which have interpreted Article 25 and 25(2) as Section 5, my Lord, which your Lordships will find in the second volume of my submission. I continue on, Dylan.
we continue up to.
Yes, great.
मैडम कह रही हैं 1 घंटा
Mr. Srivastava,
Yes.
you can just briefly make out a point in your own words.
Yes.
And then tell us that which paragraph of the note will be relevant.
I
So that
think
we-
I will do that, my lord. I precisely, I'm grateful. My lords, since now, my lords, I have to deal a little bit, my lords, Article 25 and 26. My lord, may I just, my lords, request your lordships, my lords, to read along with me for once, Article 25 and 26. I know your lordships have read it, but I may perhaps give a new approach, my lord, to the reading. I'll be, kindly have Article 25 and 26. I wish to make an important point of, my lords. Please have. Because every time, my lord, we read, my lord, we might notice, my lord,
Yes.
something new in it. Now, your lordships will please notice, my lords, the right to freedom of religion is, my lord, the heading. These are, my lords, and there are 4 articles, my lords, under this heading: 25, 26, 27, and 28. As I said to your lordships, my lords, that 25, 1 is, my lord, is the reservoir of the freedom. Kindly, my lord, now read along with me, my lord, how I make this good. Subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to, I let some emphasis on these words, entitled to freedom of conscience, and the right freely to profess, practice, and propagate religion. Well, also, therefore, the right which is, my lord, enumerated, namely profess, practice, and propagate, my lord, follows as a corollary, my lord, to the freedom of conscience. That's, my lord, my submission. Now, my lord, for the time being, my lords, please don't read sub-article 2, my lords. But now go back to Article 26, my lord, for a while, my lord, let's see. And I'll make my submission about it. Now, the marginal heading has some, my lord, some relevance. It is some guide, my lord, to the interpretation, what actually is intended, my lord, by the constitution makers. The caption is, my lord, the margin is freedom to manage religious affairs. Well, please note these words very consciously, my lords. And each word, my lords, if we had the best of the legal mind in the Constitution Assembly, in the drafting committee, my lord, the best of the draftsmen, my lords, who could possibly be, my lord, remembered in the history. Freedom to manage religious affairs, subject to public order, morality, and health, every religious denomination or any section thereof shall have the right. Now, my lord, the right of management is as follows, my lord, still in 4 clauses: to establish and maintain institutions for religious and charitable purpose, that is one set of it; to manage its own affairs in the matter of religion, that's another; to own and acquire movable and immovable property, and to administer such property in accordance with law. The idea seems to be this, my lords, in my most humble, my lord's understanding is this: that the Constitution gave to the every person, my lord, freedom of conscience. Now, how does one, my lord, practice, profess, or propagate, my lord, his belief or his common belief? When he, my lord, forms a sort of a denomination, he has to make a group, my lord. Individually, it may not be possible. So, for the purposes of, my lord, practicing and more profess, my lord, particularly propagating the religion, my lords, there is, my lord, then the concept of denomination, my lord. Denominations are formed of the people who have a common belief. Now, my lord, so far as the rights of the denomination are concerned, my respectful submission, my lord, and I commend your lordship, my lord, to a kind consideration to this, is all, my lord, derived from 25 only. Each one of these, my lords, heading to establish and maintain institution, my lords, is a manifestation or amplification, my lord, if you might say so, amplification of the right to practice, profess, and propagate religion. How do you do that, my lords? By establishing institution and, my lord, administer and for religious and charitable purpose. Similarly, my lord, to manage its own affairs in matter of religion is also, my lord, a facet of the right of profess, practice, and propagate religion, which is there in 25.1. And so also, my lord, to own and acquire movable and immovable property, because if you have to have an institution, you must have, my lord, the property also, my lords, and to administer such property, my lords. So, my lord, each one of the right, my lord, which is there in 26, is sourced, my lords, or is it is implicit in Article 25, 26 is only, my lord, amplification of that. In my greatest summation, my lord, respectful summation, 26 is not creation of any new substantive fundamental right, but it is only to give extension, my lord, in order to give implementation to the right of freedom of conscience of a person when he forms a, my lord, to become a part of a denomination. These are enumerations of the rights of that, my lord, denomination. Why, my lord? The instant, my lord, this I can, my lord, support from the other articles. 27 and 28 are also, my lord, the part of the same cluster of the rights which flow from Article 25, my lord, of the person's right. Now, that is, my lord, kindly see Article 27. Freedom as to payment of taxes for promotion of any person. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriate and payment of expenses for the promotion or maintenance of any particular religion or religious. So, my lord, this is a constitutional injunction against a compulsion, my lord, which may be imposed upon a person because that would run contrary to the freedom of conscience of that person. So he can't be compelled, my lord, to pay taxes. Similarly, my lord, Article 28, my lord, for example, freedom of attendance or at religious instruction or religious worship in certain educational institution. No religious instruction shall be provided in any educational, my lord, so this, my lord, again is something, my lord, which would be go if it is allowed, if it is compelled that you follow a particular religious instruction in an educational institution, it would, my lord, be subversive of your right of freedom of conscience, my lord, which is guaranteed under Article 25. So, my lord, what I take, and I'm deeply obliged to my lord, the Chief Justice, there is, my lord, Article 26 and 25, they operate in their own areas, so also 28 and 29. There is no conflict, my lord, between the two, because the others are only extension of the rights which are ingrained in Article 25. My lord, it is implicit in Article 25. Now, my lord, in this context, if your lordships will just have one paragraph, my submission at page, my lord, 20. Kindly have, my lord, page 20 of my submission. Well, that's what I say, my lord. Your lordships perhaps may agree, may not agree with this, my lord, but this is how I understand it.
Page
20.
That's 2.4.
I'm sorry, but perhaps in your lordships, this, 19, my lord, 19, the heading is at the bottom of the 19, page 19. Please have page 19. And what I say, my lord, interpretation of article, the freedom of the group cannot be larger than the freedom of the person. As a matter of, I should have said the freedom, the right of the group cannot be larger than. The group right, that is of the denomination, cannot be superior or bigger than the personal right. The religious denomination is a collection of persons, and those persons are the ones who have the freedom of conscience and the right to profess, practice, and propagate religion. The persons are at the core of the religious denomination of the group. Without the person, no group or religious denomination can come into being and exist. So, my lord, this is the personal right, which translates or it is, my lord, upgraded to a denominational right. By being a part of the religious denomination, the personal and fundamental right of the person guaranteed under Article 25 is not whittled down in any manner. Otherwise, it would mean that by joining the group, an individual would lose his persona or identity. Similarly, by being part of a religious denomination, a person does not lose or has lesser fundamental right than what is guaranteed by him to her Article 25. And my lord, it will have the relevance, my lord, when I have to deal with the big point, my lord, the omission of word subject to other provisions of the part in Article 26. Now, my lord, can you see article, my lord, page, the next page, interpretation of Article 26B?
No, Mr. Srivastav, your 2.3,
Yes.
is it the other way around? That the freedom of group, you have said freedom of the group cannot be larger. Freedom of the group has to be larger.
No, so
You
far
are the
as,
individual is restricted to the individual. Group means it can have that manifestation to organize, to have an institution, to create an institution and manage its affairs. Group is lesser. Group is very
My lord,
individual. I in my own home, I myself only. It's only me.
I quite see the point, my lord.
Here, Probably,
I-
I'm
I
not
guess
able to
the
appreciate
reason is this.
how you justify this statement.
Yes, my lord, the
Group
reason
cannot
is
be
this.
larger than the freedom of the person.
Yes, my lord, because if I, my lord,
It should be interpreted as an extension. Maybe to that extent, okay.
Yes.
It's an extension of the right under 25.
I'm grateful, my lord. If it is an extension of a personal right, my lord, which is there in Article 25, and my lord is merely there is a denomination, then I respectfully submit, my lord, that at the core or at the bottom of every denomination is a person. For example, my lord, if I may give an illustration, my lords, without a person, there can't be a family. When the persons they join together, there is a family. Without persons, there can't be a society or community or a
You are
society.
right. Then
But so, my
no,
lords,
the component may be a person, individual.
Yes.
But then the moment he forms an association, like a man forms an association with a woman, it's a family. The moment a man forms an association with like-minded people, it becomes a group.
so, my lords,
Association may be there, but then it has an own independent
reason is this,
identity.
my lord, why, my lord, this right of the association or the denomination has to be limited, my lord, is because if it is the person's right who have formed the denomination, then the person's right is circumscribed by other provisions of the Constitution. So, my lord, by necessary implication, the lordships will have to read that the rights of a denomination is also, my lord, controlled by the other provisions of the part, namely, my lord, the other fundamental rights. That's in that context I'm making, my lord, this submission. That, my lord, the requirement of a denomination adhering to the other provisions of the part, namely other fundamental rights, is not obligated, my lord, merely because there is a religious denomination and there is a religious denomination who has the management
That
rights.
means that the framers would not have restricted these words by adding subject to public order, morality. And
Yes, I will explain that, my lord.
only to that restrictive meaning that has to be given.
Yes.
Otherwise, what happens, Mr. Srivastava? Individually, he professes his religion, whatever he wants to profess, under 25(1). He or she will also be a part of the denomination.
Denomination.
Now, can he say or she say that I am professing that particular faith? Though I am part of this, I will not agree with this.
My lord, ordinarily, no.
Where you will have to read this as a standard
Yes,
provision.
my lord, ordinarily, my answer is, my lord, ordinarily, no. He cannot say that if there is a religious practice, if there is a practice, my lord, which, but if that religious practice is contested on the touchstone of violation of, my lord, constitutional rights. For example, my lord, Article 17 or Article Equality, my lord, or Article 21, then perhaps, my lord, he may be allowed to say, sorry, this particular assertion of religious practice violates my fundamental right. The question ultimately that the lordships will have to decide is this, whether, my lord, by joining the denomination, the personal fundamental rights of the persons are annihilated or taken away. Can he not assert being a part of the denomination? Whereas so far as the correctness of the religious practice is concerned, its origin in the religion is concerned, my lord, he cannot say no. But supposing, my lord, the religious practice, my lord, which is being imposed upon him by virtue of the being a part of the denomination, is in violation of a constitutional provision, namely the fundamental rights, my lord, my respectful submission with all humility is that he may say so. That's what, my lord, I want.
One way of looking at it is, see, Article 26 is a denominational fundamental right.
Yes.
There, the individual is subsumed in the denomination, and the denomination has that fundamental right. Therefore, this question of whether a person belonging to the denomination can question any religious practice of that denomination may not be strictly, it cannot be raised. Because if he belongs to that denomination, follows that he cannot raise a dispute. He has to go out.
It may also lead to saying that he has got dual rights.
Yeah, accepted.
Canvassing that he will have a dual rights.
No, my lord, not dual rights, no.
Denominational
No, he cannot.
Denominational right is a fundamental.
But so far as the religious rights are concerned, my lord, yes. But so far, my lord, we have to make a demarcation between the religious rights per se and the constitutional rights of that person. Now, my lord, again, your lordships will come back to the question whether, my lord, a person is subsumed in the religious denomination. My lord, that's the crux of the matter, my lord. Most of the issues will be answered by this. A person joining a denomination, my lord, loses his own persona, my lord, or personal identity. My lord, is the question. My respectful submission is, my lord, that is not the way the constitution can be read into, my lord, that a person will, my lord, merge into the person, the denomination and lose his identity, my lord. He has the right, my lord, still. He has to follow the beliefs of the denomination.
No. It can be very well harmonized for the reason that as an individual, the sphere is different. As a denomination, the sphere are different, so there's no conflict. As an individual, I have a right. So there's no that he has to be.
I could not have put it better.
That's why I understand. What you are saying is the object of religious denomination is to give effect to 25.
Yes.
Therefore, where's the question of conflict? Is mere
Amplification.
execute and that's all.
Yes.
You give effect to this, see,
25 rights, my lord.
propagate, that's all. It's only meant
25
for
rights.
propagation.
Yes. No, that's how
That propagation would include practice.
practice, my lord. Practice
Yes.
and propagation.
Propagation would include the profess.
And clauses A, B, C, D, my lord, of 26 are the facets of the propagation. How you propagate it, my lord, in the form of a denomination, in the form of a collection. Then, my lord, I move on, my lord, to page 21, my lord. Very brief submissions are there, my lord. Interpretation, please, page 21.
Yes.
26B, my lord.
20?
My lord, page 21,
Yes.
2.4.
Yes.
First is what is the meaning of
Yes, interpretation of Article 26B. The clause can be broken into following pieces: to manage its own affairs in the matter of religion. My lord, only B. I'm focusing on B because that's the central question here, my lords. The first is, what is the meaning and intent behind the word to manage? The right to manage does not mean the right to mismanage. As a right to administer does not mean the right to maladminister, as held in so-and-so Ahmedabad St. Xavier College case, so-and-so. An unlimited freedom, if conceded in favor of religious denomination or section thereof, to manage its own affairs in the matter of religion as a sequitur, it would follow that the concerned religious denomination can claim the right to mismanage its own affairs in the matter of religion, and there can be no state or legislative intervention. This will not only be illogical, but also unconstitutional, my lords. If your lordships don't read it, my lord, in this way, my lord, my respectful submission is that it becomes absolutely untrammeled, uncontrolled right of religious denomination. And the consequences that will follow, my lord, will not be in public interest. Please move on to the next page, my lords.
Question the practice of the
Told her, why did you hit a person like who's telling them about taking a person?
Further, the freedom of the religious denomination under Article 26B to manage its own affairs in the matter of religion is both expansive as well as restrictive. The right to manage its own affairs in matter of religion cannot be construed as right to exclude persons from professing, practicing, and propagating religion which is guaranteed to them under 25. In other words, the right to manage does not encompass within its fold the power of exclusion by the religious denomination. Exclusion per se is discriminatory, and exclusionary practice of religion has to be tested very strictly on the touchstone of other fundamental rights which are guaranteed under the Constitution. The expression 26B, namely to manage its own affairs in the matter of religion, must mean to manage its own affairs in the matter of religion for good, progressively, and for a reformative manner, rather than a retrograde, a subversive state. The right to manage should not be allowed to mean the right to exclude a person or a class of persons who otherwise guaranteed fundamental right of conscience and of practice, profess and propagate religion according to their. This, of course, my lord, if they have the common belief, if they have the common faith. Then, my lords, F, 23, the next page, F. Email order I am not reading. Comparing the two articles, while all persons, according to their freedom of conscience, have the right to practice, profess, and propagate their religious denomination, only have the right to establish and maintain institution, to manage its own affairs in the matter of religion, own and acquire movable and immovable property and administer such property in accordance with law. The entitlement to freedom of conscience is not of religious denomination. Similarly, the religious denomination has not been guaranteed a fundamental right, the right freely to practice, profess, and propagate religion. This again is an indicator that the right of the person is superior to right of the religious denomination or person thereof, my lord. So far as he entertains a common belief, my lord, I must add that very clearly. Now, my lords, I refer to the Vivekananda's speech, my lord, not necessary for me to read. But please now turn to page, my lord, 25. Which page? 25, my lords. Now I deal with the interplay, the most, my lords, the controversial part of it. Now, my lord, there are two aspects, my lords. Let me ask, my lord. Interplay, my lords, between Article 25 and 26 in general, then the interplay between 26B and my lord 26(2)B, my lords, in particular. There are two, my lord, interplays which are involved. My lords, this Devaru judgment was dealing with interplay between, my lord, 26B and 25(2)B, my lord, particularly when there was a law, my lord, which was made. The submission that Article 26 is superior or overrides Article 25 is not correct. Under various shades of expression, submissions have been made to suggest that Article 26 is not subject to Article 25. Article 26 is a standalone article, and Article 26 is the island of fundamental rights of the religious denomination. It is respectfully submitted that the constitution makers intended to confer both personal as well as group rights in Article 25 and 26 as a composite bundle of fundamental rights. None overrides the other, but both are designed to coexist in harmony. Article 25 and 26 are not independent of each other, but intertwined. Without a person, the group cannot be conceived, and without the group, the person of common belief cannot constitute a denomination and accomplish what is given them as right in 26A to D. This judicial act of harmonizing the two articles was craftfully done by the interpretation in Devaru's decision by Constitution Bench of the Court. Devaru has given primacy to both articles without giving supremacy to either. Lord, please, Lord, that's my submission. Both are, my Lord, important in their respective field, but no one has supremacy over each other. It is one thing to say that Article 26B is subject to Article 25(2)B of Devaru, and it is quite another thing to say that the whole of the Article 26 or 26B is subject to Article 25. The contention that Article 26 overrides 25, it is respectfully submitted, is incorrect submission when read carefully in tune with the intention of the Constitution makers. Article 26 is a further amplification of what is personal freedom of conscience and religion guaranteed under Article 25. Now, my lords, 27E, my lord, is an important submission, my lord, which I would respectfully make. If the intention of the constitution makers was to give an overriding effect, what my lords have been saying that 26 will prevail upon 25. If the intention of the constitution maker was to give an overriding effect to the rights of the religious denomination or section thereof, as per Article 26 over the right of persons to the freedom of conscience and right freely to profess, practice, and propagate religion, under Article 25(1), then it is respectfully submitted that Article 26 had been drafted differently, and its text would have commenced with a non-obstante clause, which is not so. This is a clear intent of the constitution makers that Article 26 does not override Article 25 in general. Article 26 has no superior or overriding place in the scheme of the Constitution. It follows a necessary corollary that both the articles have to stand in harmony with each other and cannot be arranged in manner that one of them would in any manner, much less by interpretation of the code, destroy or eat away the heart and soul of the other article. My lords, if, my lord, there was a non-obstante clause, and my lords, the drafting committee was well aware, my lords, how to give an overriding effect. My lord, it would have read like this. Kindly have this, my lords, for a moment. I have tried to phrase it, my lord, in my own column. Just have it, my lords. It would have read like this. Please, if you don't mind. Because the acceptance of the argument that 26 would prevail upon 25 would necessarily require your lordships to read Article 26 in this fashion, my lords. Kindly have it, my lords.
We have copies.
Yes, of course, I'll give copies.
This is the index.
If your lordships are really persuaded to accept the submission that Article 26 prevails over 25, then my lord, Article 6, in my humble submission would read like this: notwithstanding anything contained in Article 25 and other provisions of this part, but subject to public order, morality, and health, every religious denomination or any section thereof shall have the right ABCD. But that's not there.
If you read these words, this non-obstante clause, then you will have to again go back to 25 and say, if this was there, these words subject to other provisions.
Therefore, my
not
lord,
have-
that explains, my lords. Now, I get it, my lords. I now come to my main submission. The omission of subject to, my lord, is not, my lord, determinative of the scheme of the constitution. It is not.
Non-obstante clause comes, subject to would not be required there.
Yeah, maybe, yes, your lordships are correct, notwithstanding, my lord, subject to. But, my lords, but if your lordships are,
Standing but subject.
if your lordships are pleased to, my lord, agree with my submission, and I respectfully submit that Article 26 is a new, my lord, is not a new right, my lord, but it is only an amplification of right under
You
25.
have said extension.
And, my lord, subject to, it will automatically be read. My lord, it will be, and my lord, it's not subject to, in adherence with, having due regard to other provisions of the part. It will be read like this, my lord, Article 26. Because, my lord, to conceive a situation that a religious denomination is absolutely immunized from, my lord, the fundamental rights. It need not respect or follow the fundamental rights would be an extreme proposition, my lord, which your lordships may perhaps not like, because then it is capable of great, my lord, consequences, serious consequences. So, my lord, if it is only 26, automatically it would be a right to, my lord, in 25, because every right, whether it is 25 or 26, has to adhere, my lord, to the core constitutional values, my lord, which are nothing but, my lord, the fundamental rights in in part 3 of the Constitution. That's my submission, my lord. Now, please, my lord, go on to.
This is little too much. Make it less. Make it less, little less. See, actually, what is in contradiction is Article 25(1) versus Article 25(2).
Yes, I am coming to that, my lord.
Because that is nothing in this article means
I-
25(1) versus
I'll deal with this,
25(2).
I can.
In order to see if anything falls within 25(2)(a) or B, Article 26 is an aid.
Yes,
Because if it is purely secular,
yes,
then the state can make a law.
yes.
But if it is something touching upon the matter of religion, which is guaranteed to a denomination under Article 26, then it is violative of Article 25(1). It is not purely secular. That law can be challenged. That's how we have treated it.
After I finish, my lord, this part, I can address your lordships, my lord, some this.
One way, because
Yes, I know, my lord, the interplay between 25(1) and 25(2).
not between 25(2) and 26.
6,
Question here is 25(1).
1 and 25(2), my lords. May I address it? my
And
lord?
26 is an aid. He is
I agree.
a vehicle
May I
when
address
it
it?
comes to denominational right.
Yes. My lords, after I have finished this part, my lord, the subject to argument, my lords, then I'll immediately come to an answer. Otherwise, I can answer it right now, my lords.
No, we are only saying, we are not asking
Yes.
a question. We are just
Make it,
discussing that point.
I'm deeply obliged, my lord. Now, please come to page 28 for a moment, my lords. The use of the word G, my lord, 28G, the 27, my lord, I'm sorry, the pages are. The use of the word subject to in Devaru in the passage at page 918 does not literally mean subordination of Article 26, but a cohesive coexistence. My lord, that word, my lord, subject to which has been used, and these judgments are not to be interpreted like a statute, my lords. Subject to, The real intention that when your lordships will see the whole perspective, my lord, the context in which my lord subject to has been used, the lordships, according to me, only meant, my lords, that both have to be read together in coexistence.
You only said 25 to 28 has to be, they have to be read together.
Yes.
So
That's
explains that.
correct, my lords. It is respectfully submitted that the learned counsels on the other side have sought overruling of the judgment in Devaru and based their submission on overplay of the use of word subject to at Devaru. It is submitted that judgment of the courts are not to be interpreted like a statute, where the word subject to have been used in a forced paragraph in Devaru. Their lordship did not mean subordination of Article 26 to 25(2). It essentially means that powers of the state legislature having regard to the object of conferment of the power of legislation is equally applicable to Article 26 without destroying the essence of Article 26 merely because the word subject to have been used in the aforesaid paragraph. The ratio does not become untenable or bad in law if it is read in the totality of the context. The lordships only emphasize that there ought to be harmonious construction between the two sets of articles operating in the own field and nothing more. The text and texture of Constitution in Article 25 expressly and in Article 26 impliedly is to enable the exercise of freedom of conscience and the right to practice, profess, and propagate religion in manner providing social welfare reform. The Constitution is, and my lord, this is my very respectful submission, my lords, to your lordships, my lords. The Constitution is reformist and aims to achieve the goal of social welfare. My lord, this I will demonstrate from both 2A and B. It shuns the restrictive practices. This is clear from the use of language in Article 25 2B that a law can be made to provide in respect of throwing open Hindu religious institution of public character to all classes and sections of Hindu. The clause specifically speaks of throwing open. That means that the Constitution abhors restrictive practices and exclusion. It guarantees opening up. This is progressive and reformist spirit, my lord. This again is subject to, my lords, that, my lord, a person has allegiance to the belief of the religion, my lords. If he's a non-religious person, he's a non-believer, my lord, he cannot. But the one, my lord, who is a believer and who has, my lord, common faith is, my lord, normally cannot be outrightly, my lords, excluded from the, my lord, the temple. Yes. Then, my lords, religious denomination, I may not refer, my lords. Then page 30, my lord, whether the right of a religious denomination under 26 are subject to other provisions, my lords. This, I have already, my lord, made my oral submissions in this regard.
That has been argued in detail.
Yes, I would request your lordships only to read it, my lord, if that is possible and the time permitting. Now, my lord, page 33, I have a very important submission that I wish to make, my lords. There's something, my lords, I don't know how long, page 32, bottom of the page 32. I may be right, I may be wrong also, but this is how, my lords, I would respectfully, my lord, submit. The limitation in Article 26 are both express as well as implied. Now, this is in the context that the argument advanced is this, that like in Article 25, there is no reference to a word or the phrase like subject to other provisions of the part, which suggests, according to the other side, that it need not comply with the other parts. Correct? Now, this is where, I respectfully submission is, in Article 26, there is an express condition and there is an implied condition also, limitation. What is expressed is subject to public order, morality, and health is expressed, my lord. There is no doubt about it. But there is also implied, and because of the structure of the Constitution, the regard, my lord, or the position of the fundamental rights in Part 3 of the, which is non-negotiable, my lord, non-alienable rights, subject to reasonable restrictions which are enumerated. So, my lord, Article 26, there are three heads of limitations on freedom of conscience, right to profess, practice, and propagate religion, which are as follows: subject to public order, morality, and other provisions. This is 25. 26, there are two heads of expressly stated limitations, subject to public order, morality, health. In both the articles, the limitation public order is common A serious question arises that what would be meaning and extent of the limitation subject to public order both in Article 25 and 26. Public order has been used in Article 19, 2, 3, and 4 of the Constitution in relation to the restriction and corresponding fundamental rights in Article 19. The words subject to public order are very comprehensive and of widest import. Because of the express mention of the limitation in Article 26 subject to public order, the freeman has the right of religious denomination or any person thereof for purposes of clauses A, B, C, D of Article 26 can also be tested on the touchstone of condition of being subject to public order, which is different from morality and health. Lord, that's what I respectfully submit as my first submission. In our respectful submission, the limitation of being subject to public order is wider in scope than the morality and health. For the purpose of finding the meaning to expression public order and the said assistance or use same expression, and she one of these two of the 7 schedule, below that's the public order head of the legislation. It cannot be disputed that the legislature is competent to legislate matters of public order by virtue of entry 1 of the 7th schedule of the Constitution. Public order is specifically mentioned in Article 26(1), where Article 26 is read in conjunction with Article 245, 246, entry 1 of list 2 of the 7th schedule of the Constitution. It becomes indisputable that this legislature is not only competent, but also empowered to legislate in respect of the rights guaranteed by Article 26 to a religious denomination by virtue of the limitation public order. It is impossible to deny the intervention of the state legislature if such intervention is traced to the public order read with legislative power under clause B of 26. Notwithstanding the omission of the use of the expression subject to other provision apart, there are inherent and implied limitations implicit in the right of religious denomination of freedom to manage religious affairs, while public order, morality, and health are express limitations on the freedom of religious denomination to manage religious affairs. Adherence with the fundamental rights under Article 14, 15, 17, and 21, when read into Article 14, is a conjoint and harmonious manner without substantially impinging upon or curtailing the right of the religious denomination are to be treated as implied limitations. The theory of implied limitations in the constitutional scheme is now well established. A clear example, which is the case of Keshwar and Bharti, which otherwise in untrammeled power of Parliament to amend the Constitution under Article 360 was valid and subject to implied limitations, namely the plenary and constituent power of amendment of the Constitution does not extend. So, my lord, whether it is stated expressly or not stated expressly, my lords, in Article 26, that there shall be a due regard to other parts of the Constitution, namely fundamental rights. It is implicit, my lords, in Article 26. One has to read this into it. My lord, the omission is not, my lords, complete and decisive of the fact that it completely alienates, my lord, the fundamental rights from the context of Article 26. Then, my lords, in Maneka Gandhi, my lord, I have quoted that there is no, my lord, right in isolation. There is no right in silo, my lord. That is the R.C. Cooper line of judgments followed in Maneka Gandhi, which, my lord, I would skip. And page 38, my lords. Kindly, that's an important again. Harmonious construction of Article 25(2) and 26, my lord. This is subject to my first submission, my lord, which is my main submission now, that there is no conflict, my lord, between 25 and 26. If your lordships will not see, there's no conflict. But if at all there is any perceptible conflict between the two articles, then, my lord, harmonious conception, my lord, doctrine which has been adopted in Devaru, my lord, is a doctrine, my lord, or is the principle which has been well laid down. It has withstood the test of the time. It's a golden rule, my lord. And I have, my lord, in my appendix, a list of cases, my lords, which are more than, quite a number of cases, about 100 cases in this Devaru doctrine has been followed, my lords. Then, my lords, one thing, my lord, when your lordships are interpreting both Article 25 and 26, the paramount guide is the preamble of the Constitution, my lords. That's the guide, my lord, that's the best preamble. Now, if your lordships look at the preamble and my lord have that in the mind and interpret Article 26, my lord, the goals can only be achieved when your lordships would read, my lord, Article 26 in the manner that inherent, my lord, the fundamental rights observance, my lords, or compliance are inherently, my lord, built in Article 26. Then, my lords, constitutional morality, my lords, I have a very brief submission. I will not read it, page 45 of my submission. I think it's page 45, my lord, and let me explain the essence of it. I may not read the whole of it, my lords, because the lord
52.
45.
constitutional morality, my lord, is what is the scope and extent of the morality under Article 25? That's question number 4 at page 44 of my submission. Because, my lord, in a particular judgment, which I'm not able to say particular, the words used are constitutional morality. My lord, if your lordships would consider, my lord, the Sabrimala's judgment, because this arises in the context of the Sabrimala judgment, my lords. The leading opinion of the Chief Justice, my lord, Justice Mishra, he interpreted, developed this doctrine, and he said that this morality, my lord, principle in Article 26, the word morality, is akin to what is the concept of, my lords, constitutional morality. Please see this, my lord, how carefully this is, my lord, crafted. He says it is akin to constitutional morality, but when, my lord, the other opinion, my lord, which is quite an elaborate, my lord, Justice Chandrachud, my lord, he went little ahead, my lord, and he said that the morality in Article 26 means constitutional morality. There's a difference between the two. And that has created problem. In my submission, my lord, is not necessary, my lord, in the context of Article 26 to use the expression constitutional morality. Please do await this. What is required is constitutional ethos, constitutional principles and constitutional principles, the core values of the Constitution. The purpose in, my lord, in Sabrimala or other judgments would have been equally served if the lordships had said that it should be in accordance with the constitutional ethos or the constitutional goals of the Constitution enshrined in Part 3 of the Constitution, the purpose would have been served. But the complication has been created by using an expression which does not perhaps may not fit quite well in the context of Article 26 and has given rise to so much of a debate, my lord, on this. My submission, therefore, is, my lords, please read down this, the horse morality, which means political and societal morality, the principle of constitutional ethos, and the, my lord, the result would be same. Then, my lords, on judicial review, my lords, I have to say only a few words.
Because the word morality was absent in Articles 25 and 26.
Even then, my lords,
Would it have made any difference?
no, not at all, my lords, in my respectful submission.
Morality, something which shocks
Yes,
the conscience.
yes, my lord, because anything is subject to.
Constitutional morality, something which shocks the conscience.
Yes, that is correct, my lords. I'm so grateful to my lord. Then page 48, my lords. Page 48, that is about the judicial review.
Page 48.
48, my lord. Now,
As a component of ethics also,
yes, yes, my lord. Yes. Ethics.
touchstone of ethics also, whether it is ethical.
Anything, my lord, is. After all, what is morality? Morality is good conduct. Good values, good conduct is morality. And that is something which, my lord, a thread which runs throughout Part 3 and Part 4 of the Constitution.
Good social
Yes.
norms, manners.
Yes, values.
So
That is it, my lords.
we take it according to you, don't bother about the word constitutional morality.
Yes,
But you need to, you just to
Yes,
understand,
my lord,
hold the
yes,
tool to understand.
yes.
But you also agree with that constitutional morality cannot be the basis to strike down a provision of
The manner in which, my lord, the manner in which.
provision of the Act. But actually, it is nothing but it's like going back to preamble,
So,
going back to directive principle,
so therefore,
going back to fundamental right. To that extent, you can, on a combination of these, you can put it as, you can give your own name, whichever way. You can say spirit, as you say, values, constitutional mandate, constitutional philosophy.
correct, my lord.
Whichever way you could
I'm
put
so
it.
deeply, I couldn't have put it
You can
better.
find your own
I
words.
couldn't have made it
Very well.
better. But, my lord, this really makes out a case of explaining the meaning, my lord, so explaining in the context. That is what we call, my lord, in the judicial process, ironing out of the cases. Iron out of the cases instead of playing upon the word constitutional morality, my lords. That's my. Now, the next topic, my lord, is very briefly, I will touch is the judicial review. My lords, no one can, my lord, say that the judicial review is not possible. It is not a question of absence of the jurisdiction of judicial review, but it's always the question of exercise of the jurisdiction in a particular case, my lords. If a judicial review is sought in regard to a religious practice, the first inquiry would be whether that religious practice is or is not there in the religion. That review can, that, my lord, that to that extent the court can go into. But once, my lord, it is found as a matter of fact that religious practice exists,
Yes.
then whether it appeals to your notions of thinking, your philosophy, your way of thinking, or the court's way of thinking, that's not the permissible scope, because the courts cannot substitute their opinion in case of the particular religious practice. But the caveat is that if the religious practice is challenged on the ground of violation of the Constitution, the courts will, my lord, even though it's a religious practice which is sought to be asserted, my lord, the courts would have the jurisdiction, my lord, to examine that, my lord. My respectful submission is.
So can we rephrase, and Mr. Kambata also, can we rephrase your submission to mean that the right first has to be determined whether it is a religious right or not?
Practice.
I'll explain. I'm explaining it. If it is religious practice, a matter which is not connected to religion cannot be said to come under religion.
Yes, I'm grateful.
And thus protected.
Yes, grateful.
Like in your specific case, the question of marriage, that comes under the secular aspect.
Yes.
And here, the other thing is that the marriage itself is also not under the Parsi or under the Zoroastrian system. So whether that can be imported as a religious belief and then protected under 26.
Right, right.
That, according to you, could not be.
Right, my lord. May I just add, if you don't mind?
Supports that religious practice.
Well, may I just?
Doctrine has to
So
support.
whether it is religious practice itself,
Yes.
a marriage under the secular act, under special marriage, itself can come into a religious practice or not. If that itself goes out at the
Yes.
threshold, then there is absolutely nothing, no protection.
May I just, by way of a clarification, my lord, says, in that particular Gujarat case, my lord, we are both are appearing.
Most of you are appearing in that
Appearing in
particular
that
one.
case, yes, my lords. The court, as a matter of fact, found, and that's by page 58, if I am not wrong, para 58, that no text or material has been brought on record to say that it is a religious practice which is part of religion. That's a few finding. In such a case where, my lord, the finding is that nothing, I mean, you are just somebody's, my lord, predilection, somebody's opinion, my lord, that this is what it ought to be, or it is. But unsupported by, my lord, any material, any evidence, any authority, any text of the religion, then, my lord, is something which can be gone into. But why, my lord, in that particular case, the Gujarat High Court, my lord, relegated, my lord, the petitioner to a civil suit to establish a right. And again, why was this? Because according to the High Court, there is a presumption that upon marriage of a Parsi woman, there is a deemed conversion, my lord. And if you still want to maintain the position of your social status, that you have not converted to the religion of the husband, you should go and revert this presumption and go and file a civil suit and have a declaration. So it was in a different context. Now, my lords, I come back, my lord, the sequence, my lord, I have to now.
Ultimately, the whole thing is what is a religious practice? Because
Yes.
in Sabrimala, the religious practice is the basis for saying prevention of entry.
Entry.
Here, it all depends what is the nature of marriage. Hindu marriage is a sacrament. Now, Muslim marriage is a contract.
Contract.
Special marriage is a statutory marriage.
Statutory.
Neither a sacrament nor a.
Interfaith marriage.
Then, if it is a statutory marriage, here it is a prevention. Prevention of entry. There they are claiming entry. Here it is a prevention.
Prevention of entry, my lord, disallowing entry. I'm grateful.
All subtle.
No, my lord, may I just now take back and then within next
Yes,
10 minutes, I will finish.
But if it is not a religious practice,
The statutory man.
then how do you claim under Article 25(1)?
I'm sorry, I didn't get, I'm
If it is not a religious practice,
uh,
how do you claim under Article 25(1)? You.
my lord, my lord, if it's,
Therefore, the only remedy is only by a suit.
my lord,
Somebody inject you, prevents you from getting and doing this.
yes.
Let's say they are trust.
It is under section 9 of CPC.
No.
File a suit.
No, that is one,
The declaration.
but that is one, my lord. But can you see the scope of judicial review? Most of the cases, the old cases which your lordships will see, that a particular religious practice or a particular thing has a sanction of law. Some law has been framed, for example, in Sabrimala, the Kerala, my lord, there was a rule which was framed, which sanctified this particular practice, my lord, which was struck down by the, initially by the full bench of the Kerala High Court. So in that case, it is essentially a challenge to that law, the validity of that law. Number 226 is available for that purpose, my lords, if it is.
But here
It all depends.
there is no law in your case.
In the case, my lord, there is no law, there is no religious practice. So in a case where it is an established position, it is as clear as daylight that it is not religion, it is not religious practice. I think judicial review will lie, my lord, and there can be a writ maintainable against the religious and charitable endowment. That's the cases which your lordships have decided in a couple of cases. Now, my lord, I have now the last submission which I have to make is this, and I will add because
So far as your case is concerned after the review, probably you can have relief, as I repeatedly said, as my lord the chief justice has.
yes.
Otherwise, it will be difficult. For example, simple kind of partition in the family, whatever it may be. Somebody gives daughter gets less, son gets less. Article 14 will come, 15 will come, other things will come. The court can entertain all those
That's
things.
to fail. But I don't think, my lord, that a straight jacket formula, a rule of thumb
Only thing
of
is,
universal application can be
incidentally,
taken.
it is a trust and it prevents you from getting in. It is not a religious practice. And then High Court itself says it's not a religious practice. It's a simple case where you can, as a matter of course, you can go get a.
For example, in Devaru's case, my lord, how they,
You can also seek that claim, make a claim as a horizontal right under Article 15(1).
yes,
As far as your facts of your
yes, my lord, I think I.
horizontal right under Article 15(1).
Yes.
That may lie.
Now, my lord, the last submission that I wish to make, my lord, and quite quickly, my lords.
Yes.
Now, there is a lot of criticism to the essential religious practice, my lord, that test which has been propounded. And as your lordships will see my submissions in page 13 onwards.
Page 13.
Page 13, my lords.
Yes.
Is it page 13? The bottom of the page, my lord, where I have the criticism of the essential. Without prejudice to the submission that correctness of the doctrine of essential religious practice propounded in the early decisions of this court is not specifically referred to in terms of the reference. For the first time, the constitutional concept of essential part of religious found expression in Shehud Mat, which was quoted and followed in Devaru, only explained principle borrowing it from the earlier larger bench judgment of Shehud Mat. It is submitted that essential religious practice, both in Article 25, 26 attached to religious practice seeking protection of Article 25 and 26 is correctly laid down and firmly embedded in the constitutional jurisprudence for several decades. The essential religious practice test for judging the religion practice called Article 25 and 26 is a single most balancing factor between the rights of individual person and group rights of any religious denomination. It means that what is permitted and not prohibited by the tenets of the religion does not become a religious practice or positive tenet of religion. It means that a practice does not acquire a sanction of religion simply because it is permitted. It means that any aspect of the religion and every religious activity, every mundane and human activity is not intended to be protected by constitution under the garb of religion. My lord, the judgment is 1997, 4 SCC 606, page 30, para 31. It means that it is the core belief upon which a religion is founded, which are fundamental to follow a religious belief. It means that upon the correctness of the essential part or practice, the superstructure of religion is built, without which religion will be no religion. The test for applying the essential religious practice doctrine whether or not the practice is integral to the core belief of the religion, whether in taking away that part of practice it could result in a fundamental change in the character of religion and belief, and to be decided on the facts of each case. Now, my lord, this is what my submission is. One thing, my lord, which I would very respectfully submit is this, that when our lordships will have a look at the 7 questions which have been framed, the reconsideration of any judgment, my lord, has not been sought. There is no question, my lord, so far, which requires your lordships, my lord, to reconsider any particular decision, be it, my lord, Shirur Mat, be it, my lord, Devaru, be it, my lord, Dargah, or be it, my lord, Tikayat. These judgments, there is no question. Reference is not about reconsideration of any particular judgment. Please bear it that, my lord, in mind. The reason is this, my lords, that so far as I'm relying upon my research, my lord, subject to any correction that is made, no judgment up till now has questioned the correctness of, my lord, these judgments, which I respectfully submit have attained the status of locus classicus, my lords, in the jurisprudence of Constitution and the Hindu law. No judgment has questioned the correctness.
Your main argument itself goes against that. Honorable CJ has said that there's no question of harmonious construction. That's what there has been then there.
No, that is second
You said-
submission. Well, that is without prejudice to the
Without
first.
prejudice, you said.
Without prejudice to the first.
Yes.
First, I say that there is no conflict. And the second, if at all there is any perceptible conflict, the rule of golden, the harmonious construction is a golden rule and must be accepted, my lords. Well, Lord, I am deeply obliged, my lords. And there are, my lord,
Mr.
one-
Srivastava, just before we wind up, would it, as per my understanding, you have challenged the judgment of Gujarat High Court, which basically goes on the premise that there is a deemed conversion.
Yes, my lord.
That is the basic premise.
Yes.
Would it be your argument also that conversion means there is a finding of the court holds that I belong to a particular religion.
Yes,
That is directly in the teeth of 25(1),
yes.
because the right to freely profess
is how-
what I say is my religion, no court can interfere with
That
that.
is
Court cannot give a finding as to what religion you
religion you belong to.
The moment that goes, everything is consequential.
Consequences. Yes, ultimately, my lord, in that case,
The moment you
the lady
decide your faith,
the lady is Gulduk, her right is asserting her right under Article 25. She is asserting, she says that I am entitled to my own religion, my own
Exactly.
faith. And how
Given
can
by
the
the court.
court declare that I am a deemed convert? Conversion is always a voluntary act. If it is,
basic fundamental right.
it's a voluntary, that is the basic fundamental, my lord, that we are arguing, my lord, and we will argue hopefully successfully.
Thank you, Mr.
By marrying,
Thank you.
And, my
by
lord,
by marrying
Mr.
outside the
Sadu.
community,
my lord,
by marrying outside the Parsi community, she cannot lose her religion.
religion, my lord, religion is a matter of person.
Whether she can lose her religion.
That is for her to choose.
May I just one sentence only. I have relied upon certain decisions regarding the stare decisis principle.
That you have given here.
I have relied upon my lord the Chief Justice opinion, my lord, in that Aligarh Muslim University sketch, which, my lords,
Through your note, we found it.
yes, sir. So I would respectfully, my lord, like to invoke that stare decisis principle, that this judgment in Bengali community, what my lord, when the lordships are discussing the principle of overruling is this, that a judgment which is of a recent origin, past is overruling of it, my lord, is different. But a judgment which has been in existence for several years long and has been followed, well, consistently, the parameters would be very different, and the courts would be most reluctant to overrule, my lord, because that's precisely the principle of stare decisis. I'm so deeply obliged, my lord.
Thank you.
I was perhaps not entitled to much of indulgence as a second counsel, but I'm extremely grateful that the lordships were patient enough to hear me. Thank you.
Thank you, Mr. Sadu.
Sorry.
But
Yes, Mr. Sadu.
half a century ago, Millets, I started my practice in this court under an eminent lawyer, the late and great Shamala Pappu. And the first thing she taught us was start by smiling at the judges. And I pay my tribute to my senior millards as I start my argument.
With a smile.
Which I could not have, my lord.
But Mr. Raju, you got preempted. I smiled before you even. I preempted you for that. Oh, you could.
No, equally, millards, the judges should smile at the lawyers, millards. Yes, millards. I appear in IA 18931 of 2020 in the review petition, and our intervention has been allowed. I also appear in writ petition civil 740 of 1986, which is perhaps one of the oldest writ petitions pending in this court, and it has run its course, millards. 2 judges referring to 7 judges, then judges questioning why it should go to 7 judges, then 5 judges. And now I have been sent here because some questions would be common. And therefore I am addressing in my locus as petitioner there also, millards. Now, millards, Mr. Khambata and Mr. Srivastava have already given your lordships a dimension of the issues of the interplay of 25 and 26, which go beyond the narrow confines of temple entry or temple management. Therefore, when your lordships are adjudicating this larger question, your lordships need to be aware of myriad situations where this interplay happens. And therefore, if I touch upon the facts of my case, it is only to illustrate the kind of situations where these problems arise, not to be arguing the merits of my case. So, millards, I represent a group of reformist Dawoodi Bohras. And one person whose father, the late Asghar Ali engineer, was the victim of excommunication and whose family has suffered. And just as the Parsi case, which was placed before your lordships, highlighted, millards, this issue of deemed conversion of a woman on marriage, depriving her of her agency. The issue I'm highlighting here of excommunication impinges, millards, on human dignity, because here, millards, the head of the sect is called the Dai. Millards, this is a sect of Shias, millards, and there are 2 main sects of Bohras among the Shias, millards, the Dawoodi Bohras and the Suleimani Bohras, millards. And this schism happened, millards, during the time of Akbar as to who should be the Dai. And this Dai himself, millards, is said to be a representative of the 21st Imam who went into seclusion. Now, millards, the unique feature of this Dawoodi Bohra faith is that this Dai is the supreme authority. And children, on attaining the age of puberty, take an oath of complete allegiance to the Dai in all matters. I'll read out that oath to your lordships. You are the master of my life. Now, therefore, you surrender your life in all its aspects to the authority of the Dai, not just in spiritual matters, but in purely temporal matters, when I highlight instances of excommunication which have happened, starting a cooperative society without the permission of the Dai, standing for a municipal election without the permission of the Dai, reading a banned publication, not banned, but something which the Dai disapproved of. There was a magazine known as Urdu Blitz, way back when Blitz was a popular publication. So Urdu Blitz words highlighted the views of reformist Boras like the late Asghar Ali engineer. A school teacher was seen words reading Urdu Blitz. So dismissed from a Dawoodi Bohra school. So this is the extent of violation of human rights, which is highlighted here.
What is your prayer in the writ petition?
Yes, but I'm going to start.
That is difficulty. You are asking for setting aside of a judgment of this court in an Article 32 petition.
Can I, with respect, since this question was when
Yes.
Mr. Sanjay called, casually, Mr. Neeraj called, casually mentioned it, and my lord put that question. That is very much there. Let me address that separately. That question is not being run away from. The issues here are this. First comes a judgment of the Privy Council in
No, see, the
1948.
judgment of this court is a judgment of the Supreme Court of India. Article 141 is there.
I'm going to deal with that.
It may be a right judgment, it may be a wrong judgment. How do you get the judgment set aside? You file a review. Now there is also a curative or a larger bench. If it is, that's a 5-judge bench. A 7-judge bench can set it aside,
I'm going to satisfy my lords.
not through an Article 32 petition.
Can I satisfy my lord's words?
They are very apprehensive of it.
I will satisfy.
Reformist mindset, all that is different. But the road taken, the means must be as good as the end.
Your Lordship, please. I am going to satisfy my lords that unlike some recent writ petitions which have been entertained, unfortunately, in this court, which might have been passing in my lord's mind, and some, I say with great respect as a senior member of the bar, have been wrongly entertained by this honorable court, showing, my lords, if I may say so, not just lack of judicial discipline, but lack of judicial statesmanship. One day a constitution bench says Places of Worship Act is part of the basic structure of the constitution. Next day, a writ petition is filed challenging the validity of the Places of Worship Act. Notice is issued, creating all kinds of tension. And then this court has to give an interim order saying further suits will be stayed. Those are instances which need, my lords, great circumspection. But when I come here, and let me assure my lords, that this issue is going to be addressed, though it is not one of the questions framed for the reference. This issue will be argued both before the 5-judge bench to which this matter will go back. But in any case, at the end of my submission, I will squarely address this issue with reference to cases of this honorable court which deal with this principle of when a 32 petition can be entertained where a judgment of this court is questioned. There is a very detailed judgment, bullets, of Justice Ravindran in the matter, which I'll cite, and I'll cite some other cases also. So therefore, there's no running away from this. All that I wish to say at this stage, may I assure my lords that this was not a lightly drafted petition. It was drafted, and the prayer was not just what Mr. Neeraj Kaul said. It was drafted by one of the most eminent counsel and morally upright counsel to have practiced in this court, Mr. V.M. Thakunde. Rule was issued by one of the most eminent judges of this honorable court, Justice Chinnappa Reddy. After the matter has run its course through all these decades, 4 decades now, minutes, a 5-judge bench dealing with this very writ petition finds reason for reconsideration, and it articulates its reasons. All that I'm going to place, and I'm also going to place a judgment separate from this case where, with his usual clarity, minutes, Justice Ravindran lays down the principles of how and when such petitions can be entertained. I will satisfy my lord's words, but may I proceed now
I think you
With the
should
questions
start with
framed, my lords,
maintainability first. Chief,
is that, my lords, the view of all your lordships, my lords? I would rather.
raise one more, we can raise I think, another question on the maintainability also.
You can allow me.
We can argue. But
I would only request, my lords, I would only request, my lords,
You may
that
proceed
since
the
I
way,
have been sent here.
Mr. Raju,
Yes, my lords.
you may proceed the way you want,
Yes, my lords.
but just keep these two questions in mind.
Of course,
that
my lords, when a
will-
question comes from the bench, my lords, it is our duty as council, my lords, to satisfy. But all that I am praying is that since this is not the immediate subject of the reference, let me answer, and after all, I've been sent here by a 5-judge bench to address on these issues.
mentioning memo, we find the order. First is rule nisi. Then on a mentioning, the then Honorable Chief Justice, one line order, refer to 7 judge.
Yes, my lords.
Because Shirur Mat was 7 judge. The
That your
petition
court
is
corrected
referred
itself.
to 7 judge.
The court corrected its own
Article
error.
32 petition is straight away referred to a 7 judge bench.
But didn't the court later correct its own error, my lords? Justice Lahoti's bench, 2004. That 7-judge bench reference was recalled. Sometimes courts commit errors and then courts correct their errors, my lords. All that I wish to assure my lords is,
No, that
this
is
is
all
not-
on the premise that the Sayatna case can be overruled in an Article 32 petition. That is staring at us.
when I tell your lordships the sequence of how the Sayadna case itself came to this court in 1962, everything will fall into place. What was the original list? Where the Sayadna lost, after having lost a civil litigation, and because his appeal, and therefore, that's why I started by saying Privy Council judgment first. Just give me 3 minutes, words, to give these basic facts. 1948, in Hassan Ali's case, the Privy Council upholds the practice of excommunication, the power of the guy, subject to procedural safeguards such as giving notice, opportunity for atonement, etc. 1948, 2 years before the Constitution. 1949, even before the Constitution comes into force, the Bombay legislature passes the Bombay Prevention of Excommunication Act. 2 millets curb this mischief as a measure of social reform. In a pending suit by an excommunicated person against the Sayadna, and all these came before distinguished judges who later came to this court or attained Millet's great eminence. So the single judge was Justice J.C. Shah, who later became Chief Justice of this Honorable Court. And in the course of that suit, this act was shown, the 1949 Act. And the single judge held that yes, this act would cover the case of the plaintiffs because excommunication is a continuing act. This goes an appeal before a division bench of the Bombay High Court, comprising Chief Justice Chagla and Senior Justice Bhagwati. And the division bench upholds the validity of this act as a measure of social reform. Therefore, the legislature stepped in immediately, minutes, in 1949, once the Privy Council gave its final judgment. Act upheld by single judge and division bench of the Bombay High Court. Appeal filed in this court, but the appeal so the validity of an act which was tested in the context of a real and actual list, because it came up in a suit. That act, in that context which was upheld, could not reach finality. The validity of the question of validity did not reach finality in this court only because that appeal failed on technical grounds. Then the then Sayadna files an Article 32 petition challenging the constitutional validity of that very act which Bombay, which became Maharashtra. There was one intervener. So no affected person, unlike that list, unlike that suit, where the real practices were before the court, here comes a pure and simple 32 petition without facts before it. And that is decided by a constitution bench of 5 judges, where there is one dissent, where the then Chief Justice B.P. Sinha was the lone dissenter. And I am going to contend that, like 5 other great dissents, which in the 76-year history of this honorable court have later become law, Chief Justice Sinha's judgment, citing individual dignity and Article 21, deserves to become the law today. Long before R.C. Cooper, 8 years before R.C. Cooper, 15 years before Maneka Gandhi, Chief Justice B.P. Sinha saw the interplay of fundamental rights.
Merits, you may have a good case. We are not commenting on that.
I am only giving this as a background, and I will be addressing maintainability.
Just as hard facts should not make bad law.
Just a minute.
Please, Lord.
Meritorious cases should not lead to bad practices, or bad practices cannot be the means. We are very concerned with it.
The
We are
concern,
not saying anything on the merits. You may have the best of the cases. We are not saying that.
I would still require,
You can argue, but you have to address us on this.
I will not, I will minutes.
Mr. Raju, this issue you can address in the last.
Yes, Lord. That's the only permission I see.
No
That's
issue.
the only
no
permission I see.
issue, no issue. Don't
Secondly-
carry this, this preliminary objection from our side
Yes, Lord.
should not be the preliminary burden on you.
No, minutes.
You
No, I
take
mean-
this onus to be discharged in the last.
So I have been preparing to discharge this burden for the last 3 weeks since this question was first asked. So it is not that I am taken by surprise.
So we are also ultimately conditioned
Yes.
by the hard, rigid discipline on us.
Minutes.
That Article 32 petition comes, you disregard a constitution bench judgment, you start giving your own judgment, setting it aside. A 2-judge bench can do it tomorrow.
I will,
We are concerned, it's a serious matter on practice of this court.
I will answer it.
That we have to get over that first.
I will answer it with the seriousness which the question deserves.
Yes.
And I will answer it as one of the
Unless we
oldest.
get over that, how can we hear you on merits?
Minutes.
Because it is always
I
linked
think
in our,
minutes, it is fair.
that we cannot entertain a petition on merits unless this is
I think
completion,
minutes-
this, the decks are cleared.
I think it is a fair via medium when a constitution bench in this very case has said, go and address 9 judges.
7 questions.
Yes.
This question is if we
Just refer to.
take up the question.
Senior members of the bar, we also act with a sense of responsibility, minutes, and we are as interested and concerned for this court that the right law is laid down. And in a reference like this, the result doesn't matter, minutes. We are all assisting my lords in a non-adversarial way. I only assure my lords, minutes, that this question will be answered fairly and squarely. But since this is not one of the seven
Brother,
questions referred,
thank
let
you.
it be the eighth question, which I'll answer at number 8.
For
That's
the
all.
time being, you proceed
Gotcha.
on merits of those 7 reference questions.
Yes, minutes.
We know right now you can simply say it is not a gray area for this court. There is a case law,
Yes,
there is a discussion, there are judgments. We will see that entire aspect. But
First,
what
the
my sister
citation
says,
first.
Yes,
what
minutes.
my sister says is a very important question
Yes.
that we will have to
Because
respond. to
today
that.
we are here, tomorrow
And I-
we are not here, but the court is there and judges are here in future, advocates are here and the court should continue.
There
That's
is,
our concern. The apex court of this court should continue in that way.
as is the concern
Yes.
of all of us here.
Yes,
It's the concern of all of us here. Notice?
give us that citation of.
Yes, I'm giving a note, minutes. I'm not giving one case. I'm giving a complete note.
Yes,
It will be added to your lordship's compilation this evening if your lordships so desire. Which the note has been prepared. One has worked on this note ever since that question came. Minutes.
see,
Can I
yesterday
affirm, my lord?
we were saying on merits, why that writ petition was entertained in Sabrimala. Today we can't change our color and say why your writ petition should also be entertained. We are the same 9 people here.
In spite of
What
being,
came out of Sabrimala, yes, we were saying yesterday. We said, why was it entertained? Today, what we should say?
I don't want to
Both
answer.
of Article 32.
I don't want to answer the
One
Sabrimala
case,
question.
there was no 5-judge bench. In the another case, in your case, there is a 5-judge bench decision.
I don't want to answer the Sabrimala question only
No,
because
yes.
there your lordships.
We have to be consistent, sir.
Lordship.
We can't change our
Lordship.
color overnight.
Please, we hear you. Why people are so impulsive on this issue?
They argue on
We are-
merits, but keep this in mind.
We have promised everyone we will hear you.
That is my assurance to 9 judges of this honorable court, Mullers, that that issue will be fairly and squarely addressed, Mullers. Now, Mullers, before answering, and I'm addressing only on 4 out of 7 questions.
All the issues need not be addressed also.
That's right.
Some of
And
them are,
even where I'm arguing and I find that Mr. Khambata has already touched it or Ms. Jaising has touched it, I will say this has already been touched by Ms. Jaising or Mr. Khambata. Minutes. There's no problem at all because many of our submissions are on the same line. Minutes. And now, minutes,
What is that item number you are addressing?
the matter in which 901.12. 12.
90.
(901) and 11. Intervention is in 901 minutes. The intervention is in 901 and the writ petition, which is troubling the court, is 901.12. Would your lordships, just to check minutes, otherwise I will hand over physical copies. Volume 2.4, is it there before your lordships or not? Because otherwise we'll hand over physical copies.
It's not.
Because this is my argument.
Physical copy.
Yes, Manoj, we'll give it straight away.
2.4 is not uploaded.
Volume 2.4.
Yes, Manoj.
Page
Volume 2.4 minutes, 227. So while the main written submission was filed before the hearing minutes, this arguing note is filed on the basis of what has already been debated before the court, we naturally have to modulate our arguments, minutes. Therefore, your lordship may look at this note, minutes, and not go to that old arguing note at all.
Please go and copy of.
Matter of Central Board of
Dawoodipura.
Dawoodipura.
Yes, minutes.
Right.
Now, minutes. Before coming to just some illustrative facts to indicate the different kind of situation in which this controversy arises, the thrust of my submission is going to be that it is the individual who is the heart and the soul of the Constitution. Right from the preamble, fraternity, but minutes, respecting the dignity of the individual. The entire fundamental rights chapter, unless your lordships look at 29 and 30, is an individual centric factor. And I am fortified by the submissions of Mr. Khambata and Mr. Srivastav that ultimately 26 is a facet of 25, which means it's only an individual right. Therefore, if it is borne in mind that it is the individual who is at the heart of the Constitution, who is the focus of the Constitution, then all the constitutional issues with regard to interplay of articles will resolve themselves and solutions, appropriate solutions, will present themselves to your lordships. If this is kept in mind, why I keep saying individual is because of dignity, because of equality, and because of liberty. That same golden triangle. Now, minutes. This excommunication practice, I must explain very briefly, minutes. Which is, and let me also say at the outset that this is not unique only to the Dawoodi Bohra community. There can be different kinds of religious punishments in other faiths to keep the discipline of the faith. Now, for instance, words in the Sikh religion, right from Maharaja Ranjit Singh, leaders have had bullets to pay a certain price. And in our lifetimes, words, in the 60s, great Akali leaders like Sant Fateh Singh, Master Tara Singh. In the 80s, President Gyani Zail Singh, Sardar Bhutta Singh, Home Minister. And very recently, minutes, former Deputy Chief Minister Sukhbir Singh Badal. They have all at different times been declared Tankhayas by the Akal Takht. And so have been asked to atone, to do penance by doing some kind of kar seva, either serving at the langar or cleaning utensils or minding shoes in the Gurdwara. Gyani Zail Singh actually tendered an apology. The question, therefore, is not one of imposing religious discipline, which we may assume, minutes, that every religion would need to keep its flock together. The question is of the proportionality of that punishment and its impact on human dignity. Now, Millets, I am reading out from the oath, Millets, the Misak. Just give me. This will be a page 32 and the actual text of the oath. Yes, Millets. Volume 3.4, Millets, is the paper book where the long oath is set out. If your lordships don't want to read it in detail, can I just read excerpts, Millets, and give your lordships an idea? Every Dawoodi Bora boy and girl on attaining the age of puberty.
Which is the page number?
This, Millets, is page 33 of volume 3.4.
Page number of the volume?
Page 33, Millets. It's now on the screen also, Millets, if your lordships have got it. Just the Amanila's able to see, Millets. The Misak, or the oath of allegiance. Every Dawoodi Bora boy and girl on attaining the age of puberty, 13 to 15 years, is expected to take this oath, which is administered by an Amil, who is the representative of the Dai in every town, which has a number of members of the Dawoodi Bora community. There are several paragraphs of the oath, which are read out by the Amil, either in Arabic or in incomprehensible Arabicized Gujarati. And at the end of every paragraph, the boy or girl is expected to say yes. The parents of the child are to pay some amount to the Amil on this occasion. The oath or Misak is to be given to the Dai. A true copy of the Misak, which was produced before the court as Exhibit 17 in the case reported in 24 Bombay Law Report so-and-so, is set out here under. And if the Imam of the time or his Dai calls upon you to war against the enemy, then you should make war. You should help with your life and property, and you should obey the Imam of the time or his Dai sincerely. And whenever the Imam of the time or his Dai orders you to obey you, you should obey the Dai, and you shall not become a sinner by disobedience, and you shall not become hostile to the Dai. You shall not lay claim to the Daiship. All that is all right, Millets. You shall back up the Dai as true, and you shall not falsify the Dai. Then come to 4 Millets.
The document is of the year?
This, Millets, was an exhibit, Millets, in 24 Bombay Law Report 1060. We'll do the chronology.
What has been coming from when? From the start of this?
From the start, Millets, from the start. Paragraph 4, Millets, at page 35. And you shall accept the order of the Dai or Imam in all things. And you shall not use that thing which the Dai shall forbid you, and you shall not take steps towards it. You shall love whom the Dai loves. You shall be enemy to him with whom the Dai is hostile. You shall war against him against whom the Dai makes war. Any person transgressing these engagements to the Dai, he is outside the pale of religion. Whether he be great or small, whether he's a close relation or a distant one, you shall not have any intercourse with him. When I come to instances, Millets, I will show divorces have been forced upon couples because of disobedience. You shall not correspond with him openly or secretly. You shall not do any act calculated to be friendly to him, and by no manner or means or pretense shall see the enemy of the Dai. The enemy of the Dai is your enemy. And you shall attend on the summons of the Imam or the Dai to make religious war. At that time, you shall not shirk or play the coward. You shall, with all heart, spend your report fully to the Dai or to the deputy of the Dai, any person who transgresses the covenant of the Imam Uzan. Say yes, and you shall not permit yourself to be induced to withhold assistance from the Dai, service and obedience to him, and prevent you from carrying out the order of the Dai. Further, you shall not suffer any disbeliever to turn you away from taking the oath of the covenant to the Dai. You shall render perfect service with your property and with the offer of your life to the Dai. The master of your life is the Dai of the Imam of the time. It is this medieval oath, brothers, which continues till today. The Dai is therefore the Lord and Master of all the followers. Your lordships are aware, brothers, that fundamental rights can't be waived. And here is a minor taking this oath, and all these consequences which follow, these social consequences, are because you have earned the ire of the Dai. It is this social evil which was sought to be remedied. First, by the 1949 Act, and again by the 2016 Act of Maharashtra. And I'll be addressing that also, minutes in the note, because the 5-judge bench has also gone into this question of why this question still survives. I'll be placing that also.
Now, the 2016 Act, it has it has repealed this.
It has repealed that one. It has repealed. It has repealed
This,
1949 Act.
yes.
And this court goes into the question and says, in spite of that repeal, the question survives. I'll place that also now.
The Act is no more there.
Lordship, please. I'm going to
Because
place
this
that one.
court upheld the Act, but now the Maharashtra legislature has repealed that Act. Correct?
Enacted it in a different form. It's now called Prevention of Social Boycott Act. That measure of social reform continues on the statute book. This is brought to the notice of the 5-judge bench, and the bench records that the question survives. The Solicitor General made a submission with regard to how the question still survives. And that is how we are there. I'm going to place all that in that note, I assure you, lordships.
No, once the Act is repealed, will the basis of the judgment not go?
I will address that also, minutes. All that is addressed, minutes. Now, minutes, may I?
That Act which was upheld by this court.
Yes, sir.
The ramification of that excommunication is all this what is given in the oath.
I'm sorry, ma'am?
All what is mentioned in the oath are the ramifications of excommunication.
Yes, minutes, because once you have pledged your allegiance to someone who is your master for life, then you can't start a magazine.
If the Act is repealed.
I gave your lordship the Urdu
Very-
Blitz example
very
of reading a magazine.
It's very relieving. I never knew all this.
Legislature.
Very, very relieving. Yeah.
Then what remains?
Revealing.
Yes, minutes.
I'm saying the basis of the judgment.
And therefore, the Citizens for Democracy, your lordships will recall Citizens for Democracy, minutes, which was founded by Jayaprakash Narayan and the late V.M. Darkonde, who piloted this petition. They appointed a commission of inquiry May I continue tomorrow?
Probably your argument will be the 1949 Act. 1949 Act was duly protected within ambit of 25(2) as an existing law,
Yes, Burns.
right?
That's what Justice Sinha said. Yes, Burns. And I'm asking your lordships to declare Justice Sinha's
Let's
judgment.
not confuse everything with 25(1) and 26.
Lordship,
There is
please.
something which is existing protected 25(2), which is something newly created and again protected under 252. Your argument would be entirely revolving around that.
Yeah, Lordship. Agreed.
Mr. Ramcharan, you filed the writ petition in 1986. Judgment in Sayadna is 1962. What were you doing from 62 to 86?
What happened was,
Later.
it was, yes, I will answer that also. I am not one person. In the meantime, Commission of Inquiry appointed by the Citizens for Democracy, presided over by a retired judge of the Bombay High Court, late Justice N.P. Nathwani, produces a report documenting instances. So with my writ petition, and then subsequently another commission of inquiry headed by Justice Tevatia, whom both the Chief Justice and Justice Nagaratna will be familiar with, and Justice Bagchi also, because his lordship served in Punjab and Haryana, in Karnataka, and was Chief Justice of the Calcutta High Court, Justice D.S. Tevatia. 1992, another commission of inquiry on this inhuman practice among the Dawoodi Boras.
The repealed,
Yes.
repealing act
Yes.
on record.
Yes, both are.
We'll continue tomorrow.
Lordship.